Yes, CJ, we all here now?
Okay, good. We are all here. Thank you very much. Sorry.
Yes. How do we proceed today? Are you all ready to reply, Mr. Burrell, or is it Mr. Mott? You finished with what you want to say yesterday?
Yes, my lord. I think in the interests of good afternoon, everybody. In the interests of making progress and having regard to my right to put in a brief submission in relation to the new matters, I think I have concluded my response to the contractor's appeal. My learned friend will make his reply, and then we will move to the employer's appeal.
Okay.
Chief Justice, I wonder if I could ask a question of Mr. Mort.
Yes, please. Yes. Please do.
Mr. Mort, you would have seen a note that came in from Mr. Burrell yesterday evening or last night or this morning.
Yes, my lord.
Which I think puts into written form what he took us through yesterday afternoon or yesterday during his submissions. And I just want to know, you were submitting yesterday about fact findings and how he couldn't go beyond the judge's fact finding because there was no appeal against them and so on.
Right, so.
And I just wanted to be clear as to what you say. Now we have this in writing. Can I just, have you got a copy in front of you?
I have, I think. Yes, my lord, I have.
I'm not going to take you through every entry. I just want to give an example. If you take, if you go to, it may not work, but D8, yes. Paragraph number 5.
Yes.
The event is said to have been finished on 22nd October. It caused 113 days of delay, and therefore the delay started on the 1st of July.
Yes.
Which is simply 22nd October minus 113 days, I think.
Right, so, yes.
As such, notice was to be submitted within 28 days of 1st July. Well, that's simply a legal argument. And the contractor relies on the notice of 24th April. Now, I think we have findings for when the notices were given in the judgment.
Yes.
And I think we have findings as to the length of delay caused by the delay event. Again, by the judge in his judgment. I haven't cross-checked these, but I think that's right.
I'm not sure about that second one, my lord. I may be incorrect on that, but my understanding is that the judgment primarily just summarizes the position within all 4 of the expert reports, and then concludes that he prefers Mr. Singhaal's evidence within Mr. Singhaal's first report. I may be incorrect on that, but that was my understanding of the judgment.
I think my learned friend's correct, my lord, I'm afraid.
So that's interesting. So on this point, you would need a further fact finding. That's why Mr. Burrell would need a further fact finding.
That would be my position, my lord. It is something I'm going to address. It's something I touched on yesterday, my lord, and it's something I'm going to deal with in my response in relation to this fact-finding issue. But it is MESC's position that there will need to be a further fact-finding in relation to this notice provision if it is successful on ground 4, and I'll deal with that in my responsive submissions at the start.
That's helpful. That I think then I did it through asking Mr. Mort questions, but I think you've helpfully chipped in. You accept, I think Mr. Burrell accepts that further fact findings would be necessary if he was successful on his argument about Obrascon and
ground 4.
I do accept that. Yes, my lord, I do accept that.
But as I understand it, just so I'm clear, you would want further fact findings. You wouldn't be seeking to overturn existing fact findings.
Well, my lord, we would be, but I'll come on to this in my response. I mean, I can deal with it now, my lord, if you like. My submission is that it all does stem from our ground 4. And so if ground 4 is successful, anything that flows from that must necessarily also be overturned. And I was going to work my way through that logic in my opening submissions. I can deal with that now, though, if you'd like.
But I mean, as the Chief Justice, it seems to me, since we have this document, it would be useful either at some stage before we finish this part of the appeal to know precisely what each party is saying about fact findings.
My Lord, may I just since you've asked me, may I just answer my Lord's question to me, or unless the court would rather proceed with?
Yes, please.
Thank you, my Lord. So
yes,
I
Mr.
have
Moore.
indeed, thank you, my Lord. I have indeed received the document at about, I think, 4 p.m. UK time. Obviously, because of the fact that my client is in UAE, I haven't had opportunity to discuss it with my Dubai-based clients or my expert. But what I did spend some time trying to understand it. What is immediately apparent is not only is my learned friend seeking to disturb findings of fact that the judge has made, but he's also seeking to resile dramatically from the case that he put to the judge. And I can take the example my Lord alighted upon of DE8 in paragraph 5. If one has the judgment, if we have the judgment, which is B64.
B64.
Yes, my Lord. I'll just find it quickly. So what we have at B64 is an accurate summary of what my learned friend submitted. So when he refers to page A164, which is his closing submission and what was said there, that is faithfully reproduced verbatim without reduction or any change at paragraph 52, which should now be on the screen. So B64 of the judgment. And if we look at the example that my Lord just mentioned, which was DE8, this is a significant item. It's said to cause 113 days of delay. The notice relied upon at trial up until the judgment, until yesterday, is the 2nd of November. My learned friend's case at 4 p.m. yesterday was that the notice was required to be submitted by the 29th of July, by the 1st of July 18. So what my learned friend sought to do yesterday in the course of oral submission, not heralded in any form whatsoever, was to resile from the case he put to the judge and seek to rely on earlier notices. That's 8. The same is true for all of the significant delay events. So in each case, we see in the document at B64 when my learned friend said the delay notice was put in. And in order to get around this problem, he has developed, as it were, overnight, a completely new case on what notice was submitted. We see the same with delay event 12. In his submissions to the learned judge, he relied on a delay notice of 22nd of December. And his case in this appeal is that the notice was required within 28 days of 20th of October. So that's true for all of the significant delays. And
hold on. So instead of 22nd December, which he was asking for there, he now says 24th April.
Quite so, my Lord. Quite so, my Lord. And then if we look at delay, there's 2 delay events, 12, slightly confusingly, but it's the same for the superstructure and the block work, and it's the same for delay event 6. He relied at trial on a notice of the 17th of February. Wait a minute, sorry.
So your objection is basically procedural in the sense that his line of attack at the court of first instance is different, and he's now bringing in a different issue at the. But those documents that he listed out, aren't they in the record of appeal? Already they were all admitted as evidence at the court of first instance.
Yes, my Lord, they've been taken from the hearing bundle, quite so. But I mean, the point is, my Lord, that they're not. I mean, we haven't had any opportunity to address them or put them into. I mean, obviously what a notice says, what information it contains, and whether it complies with clause 20 and so on, are all fact-sensitive issues. And we say at this stage, it's very significant that this is what the contractor was contending for at trial, and it would be extraordinary for the court now to say, well, never mind what the contractor was saying at trial. It was obviously wrong about that. Let's now start looking at some completely different case in the context of an appeal where what's been said is that the learned judge made errors. I mean, that there should be some finality of proceedings, and in circumstances where a party has urged a particular case and the judge has made factual findings, none of which are disputed, it would be quite inappropriate at an appeal stage for the contractor to be able to advance a completely new, unpleaded case, not the subject of an appeal,
But
not put to the judge.
If I understand Mr. Perel correctly, what he's saying is the judge misinterpreted the principles of Obrascon. Had he done it correctly as submitted by Burrell, the judge would have gone through all those letters.
No, my lord, that's not my learned friend's case.
By the contract.
That's not my learned friend's case at
No?
all. My learned friend's case is that the delay notices that he contended for were as set out in his submission at page A164. That was his case at trial. That's got nothing to do with whether the judge misinterpreted or misapplied Obrascon. That was his case. And what's happened is we said back in, as soon as this appeal was launched, we said, well, the contractor has not explained how a correct interpretation of Obrascon would render any particular notice in time. And we raised that at the first opportunity. And now, yesterday, the contractor has gone back to the facts, looked at what their own case is on Obrascon. And as a result of that, they have had to reevaluate their own case on notices. It's nothing to do with any error the judge is said to have made. My learned friend has had to go to the delay notices he relied on at trial, abandon that case, and come up with a completely new case in order to make good this deficiency. And so that's why we now have these new notices, which are much earlier, being deployed for the first time last night.
Mr. Mort, in fact, sorry if I can just ask a question.
Please.
Your point can be taken further, can't it? Because if you look at paragraph 55 of the judgment.
Yes, my lord.
Where the judge makes his own findings and conclusions.
Quite so, quite so.
Delay claims. And you look at DE1, for example, the first one. The judge makes a finding. These events were notified for the first time when MES served its particulars of claim in 3rd November. It's a finding of fact. And what Mr. Burrell says in paragraph 2 of his new note is that he rely upon notice of 14th September 2017.
Right.
But that would involve changing the judge's finding of fact.
Exactly.
And replace it with a new finding.
Quite so. And when my learned friend provided the note, I did ask him, was he seeking to amend the grounds of appeal for that purpose? And he confirmed that he had no such intention. So the court doesn't have jurisdiction to investigate this, however tempting it may be to do so. But I'm grateful, my lord. I accept the point made, and it was, I believe, a point we made in oral submission yesterday, but now enhanced by the production of this document.
My lords, if I might address these issues.
Wait, let's have you finished with what you want to say, Mr. Port?
I think I have, my lord. Thank you. Unless there's any questions.
Thank you very much.
Thank you.
So, my lord, there's two issues. The first is whether it is necessary for the contractor to have separately appealed the factual findings at paragraph 55 of the judgment. That is one issue. The other issue is if the contractor was not required to appeal those findings, and as a result of being successful on ground 4, the judge's factual findings in relation to notices are set aside, what is the Court of Appeal then allowed to do, and what evidence is it allowed to consider? The first of those, in my submission, it is not necessary, or it was not necessary, for the contractor to have appealed specifically the factual findings in paragraph 55. The reason for that is if I go, if I think we're already on it, if we go to B64, and you can see here what the judge is, this is the judgment, and the judge has said at paragraph 52, and this is common ground, the judge has cut out verbatim the contractor's submissions here, which is from the contractor's closing written submissions about each of these delay events. And there's a paragraph in relation to when notices were issued for each of those delay events. If we then scroll down at paragraph 53, the judge references Aikenhead's judgment in Obriscon and the contractor's argument in relation to that. The judge then says, if you scroll down to the top of the next page, I respectfully disagree with what the judge said if that is what Mesk alleges, and he sets out his different interpretation of clause 20.1 at the very top there. Now, this is the next very crucial paragraph, paragraph 54. It follows that I reject Mesk's contentions in its closing submissions that due notice was given by reference to the critical delay event set out in paragraph 52. So the judge has entirely predicated his rejection of all of Mesk's submissions on when notice was provided on his rejection of Obriscon. They are entirely connected together. He effectively ignores all of Mesk's submissions on notices because he rejects Obriscon. As such, if the judge is wrong on Obriscon, the rejection of Mesk's, sorry, my lord.
That's simply not right, because the judge, go back to the example I put to Mr. Mort. D1, look at paragraph 52 first. This is your contention, yeah?
Yes, my lord.
Delay event 1, Mesk issued its notice of delay 14th November 2017. That's what you were putting forward.
Yes, my lord.
That's all right. Then the 14th November 2017. At 54, he rejects your contentions about due notice having been given. I understand your point about that. But 55, he actually makes a finding. He doesn't accept your November 2017 argument. He said you were notified for the first time.
The reason for that, my lord, though, and you can see it at the start of paragraph 55, is he says, I turn to examine and give my conclusions on Panther's contention that all of these were notified after the expiry of the 28th of delay. And as such, he is only relying within paragraph 55 on Panther's submissions as to when notice was provided. He ignores Mesk's submissions as to when notice was provided. And the reason he ignores Mesk's submissions is set out within paragraph 52. He says he rejects Mesk's contention that due notice was given because of Obriscon. So he effectively ignores Mesk's submissions on...
Mr. Burrell, he also rejects your contention that notice was given in November 2017.
My submission, my lord, is... Sorry.
He prefers Panther's submissions on that.
My submission, my lord, is that the reason he only looks at Panther's submissions is because he's made the decision that he's not going to look at Mesk's submissions. He's not looking at when Mesk has provided notice because he rejects Obriscon. That's evident from paragraph 54. He says...
He is looking at when Mesk first gave notice. He says, well, we're notified for the first time on a certain day.
My submission, my lord, is that the reason he is only doing that is because he's made a decision to ignore Mesk's submissions as to due notice, which flows from paragraph 54, because of Mesk's contention in relation to, because of Obriscon. It's because of that together that they all necessarily flow. It's because he rejects Mesk's submissions for Obriscon that he then ignores the notices that Mesk rely upon. He effectively ignores all of the submissions at paragraph 52 of his judgment as to when notice was issued. He says, because I've rejected Obriscon, I therefore don't need to look at what Mesk has said in terms of notices. And therefore, I'm only going to look at what Panther says. This is what Panther says, and as such, I find for Panther. That's effectively what the judge says, and it's all based on Obriscon.
Okay.
Yeah, but 54, I read it. The question is that a finding of fact by the judge irrespective of Obriscon? It follows that I reject Mesk's contention in its closing submission that due notice was given by reference to the critical delay events as set out in paragraph 52. How does that sentence relate to Obriscon?
Because he said it immediately follows paragraph 53, paragraph 53, he refers to Obrascon, and in paragraph
Yes.
54, he says, and I'm in my submission, this is a finding of fact. He is finding as a matter of fact that MESC's contentions in relation to due notice are rejected. And as such, because of that finding of fact, if MESC is right on Obrascon, that finding of fact and anything that flows from that must necessarily be set aside because they're all tainted by his decision on Obrascon. Paragraph 54 immediately follows paragraph 53. Paragraph 53 deals with the judge with his decision on Obrascon, and in paragraph 54 he says it follows as a result of my rejection of Obrascon that I reject the MESC's contentions, and he even specifically refers to paragraph 52. He says because all of what MESC has been saying in paragraph 52 about when due notice was provided, I reject because of Obrascon. That is a finding of fact. And if the judge is wrong on Obrascon, the judge is wrong in that finding, setting aside, therefore, all of his later findings of fact, which are connected with this wrong finding. It's all related and it all flows. In my submission, sorry.
Our decision will be the basis on how we interpret Obrascon.
That's MESC's position, yes.
If we agree with the judge, then we don't have to look at the facts. We just accept the facts as found by the judge.
Correct.
If we agree with you, then we have to re-evaluate the facts as found the judge, right?
Correct, yes,
now,
my lord.
The question, I think the contention here is, do we have that right to evaluate that at this stage at the Court of Appeal, finding of fact?
Well, my lord,
you say yes, because they are all based on documents which were part of the trial.
So
submitted in evidence at trial. That's what your contention is.
So yes, my lord, this is my second point, or dealing with the point my learned friend raised this morning. Firstly, yes, the Court of Appeal is placed to deal with findings of fact, and if it considers that it's not, then it can be remitted. Just because, so when a decision is made, when a wrong decision is made in law, any findings of fact that are premised upon that decision, as I would submit are the judge's findings in this case, must necessarily be set aside. And as such, the court is then concerned about having to make new findings of fact. If this Court of Appeal considers it's in a position to do so, very well. If it needs to be remitted, then so be it. But just because new findings of fact need to be made doesn't mean that this part of the appeal can't be overturned. It's very common in appeal proceedings.
But because these are documentary evidence, assuming you are with you, assuming we have to re-evaluate the finding of facts by the judge, we can make our own finding of facts because they are all documentary.
Yeah.
You're not relying any oral evidence at the court of first instance where you have to cross-examine the witness and things like that. This is not a rejection during trial where there's an objection to a certain statement where then we have to send back and say, no, you should have allowed this statement to come in. Here is your basis are documentary evidence, which were part of the file documents which were submitted or agreed to at the trial, right?
Entirely correct, my lord. So my learned friend sought today to suggest that the contractor was resiling from its position, and it is true that some of the notices relied upon were not explicitly referenced within that section of the contractor's closing during the initial trial proceedings. Many of them were, but the fact is that all of these notices, in one way or another, were drawn to the judge's attention within the closings and during the trial proceedings. They're all part of the initial trial proceedings. All of the documents are there, and you can see within my note yesterday, you can see where these notices were all referenced. So some of the notices were referenced within other notices. So the notices of 24th of April and 19th of July were referenced within a notice of the 2nd of September, etc., etc. So all of these have previously been referenced at some stage. Annexure 4, for example, was an annexure from Mr. Singh's first report. That was that the judge was
lost you
during the proceedings themselves. So all of these notices were there for the trial judge to review. I appreciate and I understand my learned friend's point, but the query for this court is, if this court is with me that on ground 4, firstly, in terms of Obrescon, and then also with me that if ground 4 is successful, this necessarily means any findings of fact predicated on that ground in my submission, which includes the judge's wholesale rejection of MESC submissions on notice, also fall. The question for this court is, well, what documentary evidence can it look at under a new factual review? And in my submission, it's any documentation that was before the trial judge, whether the contractor relied upon that explicitly within closing submissions or not. It's any documentation that was before the trial judge. It's that is the end of it. And as such, in my submission, the notices that are relied upon by the contractor in this appeal, this court can review and rely upon in relation to its decision on whether notice was given.
Yeah, but for you to rely, while we are still on this point, for you to rely on subclause 20.1, there are certain things, as I was asking Mr. Mott yesterday, you have to first prove you are entitled to the extension. You are entitled to the extension. And the answer given by Mr. Mott was entitlement to extension. There's so many provisions in the agreement which where contractors are entitled to that extension. But for this purpose, let's accept that they are all your entitlement because they are stated in your different letters and things like that. So, but if, oh my God, I lost the fish. If you look at Mr. Aikenhead's judgment,
Yes, my lord. Which paragraph?
B63. B63.
B63. Thank you, Lord.
There's certain parts of the judgment I was reading, I don't quite agree with his conclusion. He said that if it is not done within 28 days, then never mind, leave it there. I'll read through them again later. The wording is not the wording of 8.4. But for your contract, you don't apply 8.2. The 8.2 is deleted for the purpose of your contract, is it?
No. In relation to the provisions that Aikenhead J is citing, those are exactly the same as in this contract. There are some other amendments which with to 8.4, but that they don't affect this part of the mechanism. They're exactly the same between the two for this purpose.
Yes. Okay, never mind. Just I'll go to this again later.
Thank you, my lord. Unless there's anything else arising from
here.
Sorry, my lord.
Yes.
Is there anything else arising? So I was going to address. I can address ground 4 now in my response, and then I'll come back to the other responses because we're on it now. But is there anything else that my lord would like to ask in terms of the notice issue, in terms of when? Sorry, the notices in terms of when they were provided and whether the factual findings were appealed or not, or it's necessary to appeal, or anything in relation to that.
I'm sure Mr. Mott is going to ask his team to go line by line what you emailed yesterday and check whether all your facts stated in that document is correct. I'm sure they're going to go line by line. And then...
Thank you, Lord.
My Lord, just for the avoidance of any doubt, in circumstances where it was a huge part of our response to the appeal, among other facts, that the contractor has not identified any notice that would be within time, if the ground 4 succeeded, we are absolutely taken aback that after submissions yesterday, we get for the first time a written statement of what notices my learned friend relies on, and one that is contrary to, as he just conceded, contrary to the case he put to the judge. And the suggestion that, well, these documents were in the trial bundle is several thousand pages long. I'm not instructed to deal with it.
No. Mr. Mott, the list that Mr. Borrell submitted was at the request of Judge Lord Glennie,
Of course.
because he said, "Can you put everything into one page and give?" And that's what he did. Nothing more than that.
But his oral
Except that
submission.
at top of the page, top of the page, he said that if a BRESCON is not accepted or accepted, then it goes down. There's nothing new. Otherwise, we judges have to go page by page, exhibit by exhibit, to check what has now been summarized into one page. That's all.
No. The document is a written record of his oral submission. I accept. His oral submission yesterday, putting forth this analysis, is wholly new, wholly contrary to the terms of his appeal and contrary to the terms of the case he put to the judge. And I am not in a position today. Well, I've finished my submissions on the appeal. I'm not in any kind of position to address this. So far as I'm aware, that there is no appeal on factual matters as to when notices were given. So it's not something I have any instructions on. That was as I say, that was for the avoidance of doubt. Should there be any, should anyone think our position was different to that? But my lord, I'm conscious we need to proceed with the
Don't worry about time. We were discussing this morning before we started this. Don't worry about time. If you need extra time, please, don't rush through. We judges need to understand also what you are saying, what you are submitting. That's very important. And yesterday I realized, Mr. Mott, we interrupted you quite a bit, and therefore you ran out of time. I'm not very strict about time. And I think Judge Ali has already indicated to the registrar in Dubai that they may have to sit a bit longer today. So be it. Let us understand everything rather than struggling to understand after you all left. You leave us, and then it's more difficult. So if you need extra time, so be it.
Well, I'm sure my friend and I appreciate that.
A client is another matter. How you charge your clients is another matter. But with us, don't worry about the time. Okay?
Thank you, my lord.
Yes.
And of course, I welcome any interjections or questions.
Yeah. Okay, Mr. Burrell, please continue.
Thank you, my lord. Just finally, before I move off this issue, and I understand to a certain extent my learned friend submissions, but this is not the vast majority of what was submitted yesterday in oral submissions and as contained in this notice is not new. It is and formed part of MESC's closing submissions. It was addressed in my first supplemental skeleton. The delay events are all the same. It's only that there's certain new notices relied upon in relation to 3 or 4 of the events. Now, those notices were previously or are referenced within other notices or otherwise. And in any event, in my submission, whether it's new or not is actually not entirely that relevant. That the point is, if the contractor is correct on ground 4 and correct in terms of the factual findings needing to be set aside, as it submits it is and has been its position throughout, albeit my learned friend makes technical arguments about what paragraphs were specifically to be set aside or not, but in my submission they all flow from OBRESCON. In any event, there needs to be a new factual finding review, and if the court is not in a position to deal with that today because the contractors or the employers not not provided their submissions on these notices or not, then that's fine. If my learned friend needs to deal with that in a later written submission or if the court needs to remit it, that is fine. But the point is there needs to be a new factual review, limited factual review. And as such, when that factual review is undertaken, the evidence that was before the trial judge can be relied upon by the contractor, even if even if it wasn't referenced within a specific closing submission previously, it all becomes relevant again. So that is the point. Finally, so just very briefly on this, I realised last night after I'd submitted this note, there is a minor correction to this note at paragraph 7, D12, it's a block work delay event. So it says this finished on the 31st of December. That should actually be started on the 31st of December, because that's when window 3 starts. So the notice is to be submitted within 28 days of the 31st of December. Apologies, that's just a brief correction. Okay, so those are the submissions in relation to that notice issue, and I think we've dealt with that now. briefly, while we're dealing with ground 4, I'll respond to some of my learned friend submissions on ground 4. If we're at B63, towards the end of my learned friend submissions yesterday, he suggested at one point that a notice was required when the delay event or circumstance actually occurs. But I'm not sure if exactly what my learned friend was referring to there. He appeared to suggest that, for example, when the variation instruction was actually issued, that might be when the notice was required. I apologize if that's not what he was suggesting. But in any event, that is an incorrect analysis on any view, even if my position is not accepted, because under 20.1, it's only when the event or circumstance is at the very least deemed to cause future delay, actual critical delay, not when it actually happened. So at the very earliest, it's only when it's foreseeable that the variation or instruction or what have you actually will cause delay. In my submission, that in itself is also not the correct analysis, as based on Obrascon, it's either when it will be delayed or when it is actually delayed, not whichever is the earliest, which is Obrascon's point. Also, just briefly to correct, although I think my learned friend moved away from this point a little bit towards or through his submissions on this, my learned friend had initially submitted that Obrascon is in fact not different to the initial judgment in any event. It is different, because you can see within this example, it is obvious that the variation will cause future delay in October, and it only actually causes delay in November. Obrascon's Judge Aikenhead says the notice is actually only required within in November, when the delay actually occurs. So it is very different from this judgment. There is a difference. It is, Aikenhead J says it's when the delay actually occurs that a notice can be provided. So there is a difference, and MESC relies upon Aikenhead J's judgment in relation to the same. And as stated, the submissions made yesterday about contra preferentorum for EOT mechanisms. So those are my submissions in relation to ground 4. Briefly dealing with a couple of points that my learned friend made in his opening submissions. My learned friend sought to suggest that it's not really an employer who is responsible for most of the delay. It's either other parties or an engineer or similar. But the underlying theory behind the prevention principle applies to all of that. If I go to I3, and these are extracts from some of the oldest authorities on this, from the 1668 authorities, and looking at paragraph 11A, halfway through that paragraph, if a condition of the contract is that the house is to be repaired, he is to be excused from this if a third party, at the command of the obligee, obstructs him or does not want him to suffer. So even if third parties cause it, the prevention principle throughout has been in relation to those points. My learned friend also sought to suggest in his opening comments that looking at the movement of the FIDIC contracts and developments, modern developments are away from the fairness enshrined within the prevention principle, and seeking to dissipate it. I wouldn't agree with that. Firstly, there is a different position in relation to how contracts are drafted in Australia, and that's cited within some of the authorities, in particular the article from Doug Jones. And that's possibly because of gay mark. Gay mark is the only ratio decidendi, as far as I'm aware, in relation to this. There is no ratio decidendi in England about this point. Multiplex, the comments made in there are obiter. So I would reject the suggestion that this is the movement in relation to the prevention principle. In relation to ground 2, so in respect of clause 3.5, my Lord Glennie yesterday suggested that there was a formulation that if you did not give the notice, you had to get on with it, but that didn't stop the contractor from raising the point, or either party raising the point after the end of the works. In my submission, there is the clause 3.5 does permit such an interpretation, I'm just responding to a point that my learned friend made, and again, I apologise if my learned friend's point in relation to this is different, or I've got this wrong. But my learned friend countered this point by reference to the fact that there were various clauses of clause 20, and that's what I've noted down. And to the extent that that is relevant to this court's consideration of the interpretation of 3.5, I just wanted to correct that in this contract, all of clause 20, apart from clause 21.1, was changed. It was all removed, providing solely for a mechanism to go to court. I think if we go to C171, and down at the bottom, delete clauses 20.2 to 20.8, and then it just provides for resolution of the dispute, and then reference to going to court after 90 days. So it takes out all of 20.2 to 20.8 to the extent and I apologise if my learned friend wasn't trying to rely upon any of those provisions or had made that clear, and if that was a misconception on my part. But as such, I submit this is the only mechanism for going to court after the contract. Before that, the only other mechanism is engineer determination. And as such, similar to some adjudication provisions, an interpretation is possible whereby the engineer determination is only an interim determination, and parties can go to court afterwards. Finally, in relation to this, my learned friend suggested that clause 3.5 was not required to be construed contra profferentorum because it's not part of the EOT mechanism. In my submission, as EOT claims are required to be submitted to clause 3.5, it's still concerned the EOT mechanism, and it is still possible that due to a failure to provide notice, a contractor is liable to pay an employer for employer delay. All of this contra profferentorum arises from the prevention principle. And so if there is a situation or a clause which makes it possible that a contractor will pay for employer delay because of a failure to comply with a notice provision, that is required to be construed contra profferentorum. Further, and in any event, Article 54 of the DIFC contract law in relation to contra profferentorum is of wider application in any event. So I would still submit it needs to be construed contra profferentorum. Finally, in relation to I know we've dealt with the notice issue. I've just got one very minor additional point in relation to this notices issue and whether factual findings needed to be appealed. And again, if my learned friend made this point yesterday, perhaps I missed it. But my understanding is my learned friend was mainly focused on ground 4 in terms of whether the judge's findings in terms of notices were to be set aside. But this point can be compared with MESC's ground 1 and 2, as if MESC is successful on grounds 1 and 2, this would also have an effect on the factual findings. Now, it wasn't my understanding that yesterday that my learned friend had suggested that if MESC was successful on grounds 1 and 2, this would have no effect because the factual findings, for example, in paragraph 55, were not appealed. But that's because it's obvious. Any factual findings that are predicated upon an incorrect analysis of the law must necessarily fall away. And as such, that's the same as I would submit in relation to ground 4 and the wrongful rejection of Obriscon.
You keep talking about findings which are predicated upon a wrong analysis of the law. But there's two different situations, aren't there? One is a finding that, for example, the clause requires notice within 28 days. Finding of fact, notice was not given in 28 days. Now, if he's misinterpreted the clause, then that finding is open again. I understand that. But if he says notice must be given within 28 days, i.e. by end of December, and he says notice was given too late, the first notice was given at the end of January, that finding that the first notice was given at the end of January is not predicated upon the misunderstanding of the law. It is simply a fact finding which stands unless it's appealed.
Yeah, well, I've explained my submission already in relation to this point, my lord, which is that the reason why the judge made those fact findings was because he was only looking at Panther submissions, and the reason why he was only looking at Panther submissions was because he had rejected MESC submissions because he had rejected Obrascon. So it all flowed from the same point.
Okay.
In relation to ground 5 and 6, I've just got 2 points in response, which is, firstly, my learned friend sought to suggest that the prevention principle is a rule of construction and as such requires careful drafting, and that clearly a party is taking on a responsibility they would not ordinarily do. Whilst I'll come back to this rule of construction point, I do agree that very clear words are needed. Very clear words, which few men would agree to, as per Dodd and Churton, are needed to contract out of the prevention principle. My learned friend suggested that clause 20.1 is very clear words. I'd respond that is not the case. My Lord Glennie yesterday suggested that the clause itself did not reference liquidated damages. As such, it's not clear that these would be imposed if there was a failure to provide notice. Well, that's exactly the point the contractor makes here. If it's not clear to this court, it would not be clear to an ordinary contractor that it is agreeing to accept liquidated damages for employer-caused delay if it fails to submit notice. It's just not that clearly worded. Yes, that is the effect of the provision, but it's not that clearly worded. If it was stated in terms that a contractor agrees to be liable for liquidated damages for employer delay if no notice was provided, I suggest that very few contractors would agree to that. The second submission that I have in relation to this is in relation to this rule of construction point that my learned friend made. My learned friend, in making this point, seeks to undervalue, I would suggest, the importance of the prevention principle. It's a principle of fairness and requiring fairness. And my learned friend's submissions on party autonomy do not adequately address this. My learned friend's submissions effectively amount to, well, it's all a question of party autonomy. Parties can agree to what they want to, except parties can't if it's contrary to the law. And so the question is, when does the law intervene with a party agreement in relation to this? When can you and can't you contract out of the prevention principle? And in my submission, it's a similar point to like that of penalties, only very clear words. Devalue the underlying importance and fairness of the prevention principle, there for over 450 years, as an important point of fairness, namely that it is unjust if a party is able to benefit from its own wrong. As stated yesterday, I would suggest a way of dealing with this unfairness would be a reformulated prevention principle which attaches just to liquidated damages, not the date itself, and ensures that an employer does not profit from its own wrong. A modern approach which deals with complaints from both sides, as posited by Doug Jones. And I don't think I gave the reference for that yesterday, but in the Doug Jones article, I won't go to it, but that's at E115. And finally, dealing with the new ground 8, which is the discretion of the court to alter liquidated damages if they're grossly excessive pursuant to Article 22. I understand my learned friend will respond to this in writing, but this ground concerns the court's discretion to reduce. So it's the court's discretion to alter the party's express bargain if it considers they are grossly disproportionate to the loss that was actually suffered. As such, my learned friend's submissions as to party autonomy do not have the same application to the court's exercise of discretion on this principle. And finally, as it's now part of the bundle, Article 15 of the Law of Remedies, which I referenced yesterday, is now at page E773. Those are all my submissions in response.
Thank you very much. Any questions from the judges?
Not from me,
No.
thank you.
Okay, thank you very much. So now, Mr. Mott, it's your turn.
My lord, so now, thank you for my learned friend. So now I propose to make our appeal, and we did a draft timetable for today. I was proposing to speak for 90 minutes on the employer appeal, and we had scheduled a break for what would be 7:30 in Malaysia or 3:30 in Dubai.
Most grateful for that. Thank you very much.
Is that the most convenient? So if I speak
Yes,
for
yes.
90 minutes,
I'm most
that will
grateful to
be,
you.
and then we will break at 11:30, whether I've finished or not. Grateful?
Okay, thank you very much.
So I'll be as brief as I can. So, my lord, the employer has appeals of two kinds. The first one, ground one, concerns the expert delay evidence and the court's decision as to what sanction to apply for the contractor's breach of a court order, which I'm going to deal with first. The second group of appeals are some miscellaneous items of loss that the employer suffered, some quite significant, as a result of the contractor's breach of contract. So those are grounds 2 to 5. So if I deal with first with ground 1, which is a sort of standalone point. Now, if we go to the judgment at B122. Paragraph 193. So I hope you can.
Sorry,
So there's a heading at para 193, it should be on the screen now, the missing P6 native files. And the learned judge introduces the point by saying, to begin with, in assessing the delay analysis, I must deal with Panther's submission that the failure by the contractor to produce as ordered by the court the P6 native files relating to the period from July 17 to October 19 should result in the wholesale rejection of the contractor's expert evidence on delay. Now, just to be clear what we're referring to here, the P6 native files, I'm going to explain very briefly what they show, although the learned judge does so a little bit at 193. The P6 native files are what's necessary to do a delay analysis. The contractor provided them to their expert, and he didn't really use them. Now, that itself is a huge red flag. So the contractor's own delay expert decided not to use the P6 native files. At the same time, the contractor was ordered twice to provide them to my client so that my client's expert could interrogate them. And the contractor on those occasions failed to comply with those orders. Now, in the appeal yesterday, my learned friend said about a dozen times how his client was only responsible for a very small proportion of the delay, and that we, the employer, were responsible for 96% of the delay, I think was his statistic. But that's only because the court adopted the contractor's case on delay in circumstances where my side didn't have the essential equipment with which to contest the delay case. So it's not massively surprising that the court found the contractor's case preferable. We didn't have the material that was needed. Now, if I can just put this in context, there's a helpful quotation at page B81 of the judgment. Paragraph at the top of B8, so something's gone wrong. The top of B81. So this is summarising Mr. Allen's delay expert evidence. He refers to the SCL protocol, which I'll take the court to in a moment. Mr. Allen, so at the bottom of page B80, paragraph 109, Mr. Allen is reported in the judgment as saying that the SCL delay and disruption protocol states Typically, delay analysis requires the identification of the critical path to the completion date. And I'm sure the court's aware, the critical path is the sequence of activities out of the many hundreds or thousands of activities that determine when the project will complete. And the court will recall Mr. Justice Aikenhead referring to the criticality of the delay being a precondition of knowing that one has a delay claim. And the court refers to my client's expert, Mr. Allen, and his assistant, Mr. Clark, did not establish a single critical path running through the project. He said that was made impossible because the P6 native files had not been disclosed. So at this trial, which was primarily a case about delay, as the court can see, the employer's expert couldn't prepare a critical path analysis for the whole project, and he couldn't do that because he didn't have the necessary software from the contractor that would enable that to happen. Now, it is still, obviously, it's still possible to carry out a critical path analysis, but it is going to be of a very facile and superficial kind. Now, the material, what the P6 native files show, for anybody who's had the joy of doing a complicated delay case, is they show the numerous activities involved in the project, how long they'll take, what lead-in times are necessary, for example, for the preparation of drawings, submissions for approval, and so on.
Mr. Moore, can you just help me? Assume I'm totally ignorant about P6 native files. Are they files containing data, or are they files containing software that enables you to analyze the data?
I think the software is called will be Primavera, and the P6 is the data it's data that will be analysed by the software.
It's peculiar to the particular contract.
Quite so. So the contractor will create the program and load it onto the software. So the contractor will decide what activities they have to perform. I mean, in minute detail, it will be if one were to print it out, it would typically fill files if printed out in full. So the contractor will decide what activities they have to do, how long each such activity will take, so the planned duration based on their experience, and crucially, the contractor will set out the relationships between activities. For example, in a typical tower construction, it's going to be necessary to do the construction, the foundation concrete before one starts the superstructure. Yep. And then there will be a series of floors made out of concrete and steel in the way that modern buildings are. And then once the superstructure is complete, then there will be follow-on trades doing the first fix M&E, and so on and so on. Obviously, with any kind of, this is a residential development, so it's not quite as I've described, but the point is that the contractor knows how they plan to do the work based on their experience and their subcontractors' requirements. And they also know, because they have planners in their team, or should have, what the relationship between different activities are. So as an activity is finished, follow-on activities can then be started. But then there are obviously other follow-on activities that don't have the same dependencies. The point is that back in the day, in the 1980s, people would do all this manually, and it would be incredibly difficult. But as projects have got more and more sophisticated, it's all now done by software. And the joy of it is that with a well-prepared program, one can see in prospect or retrospect what the impact of a given delay event is on completion of the project, because the contractor, having put in the logic links and so on, obviously those themselves can be challenged, and the employer might say, well, these logic links are inappropriate. But the point is that the contractor, having planned the work, assuming the contractor's done a competent job, one then can make an objective assessment of, well, what is the impact, the genuine impact of a delay event on that program as planned. Now that's how it should work. And the contrast is, if you don't use the software, if you just do it manually and with a pencil and ruler draw up your own programs, or just extract material, it is extremely easy to manipulate the program so that the things that you're complaining about have the appearance of being the sole cause of all delays throughout the project. And that's why you then end up with the result, as happens in this case, where 96% of the delays are said to be the employer's responsibility. Well, of course they are, because the delay analysis being done here has not been done in accordance with normal standard procedure for the last 20 or 30 years. In the contractor's case, because their expert chose not to use the material, and on my client's case, because obviously we were seeking to attack the case being made, because the contractor, in breach of 2 clear court orders, refused to provide the material to us. And that's why my learned friend can say with such glee that we were responsible for 96% of the delay. Well, yes, based on their wholly superficial analysis, without not done in a proper way. Now, my lord, I just need to mention one other point before I develop this. There is a clause in the contract at C156, which is an amendment at clause 8.4. So I'm in page C156, clause 8.4 is amended. There's an addition to say, under no circumstances shall the contractor be entitled to any additional payment or to an extension of time in respect of any concurrent delay. In other words, if there's an employer delay going on affecting the same period or same activities or same durations as the contractor delay, the parties have agreed that the contractor won't get more time or more money. And that's although that's an amendment, it's quite a common sort of amendment in the region and in the jurisdiction, in my experience.
Which clause was that?
8.4. It's an amendment to 8.4, which deals with extension of time for completion, and it was on page C156. Now, the relevance of that is that the P6 native files are going to be particularly important for ascertaining what contractor delays were going on. So when the contractor makes their delay claim, I mean, this isn't just this project, this is every project. I'm sure my learned friend's experience would be identical. The contractor, when they make their claim, will seek to emphasize the drastic consequences that the employer's delay have caused. So, for example, where information is late. And it will similarly be the contractor's intention to downplay their own culpability, their own failings, lack of resources, failure to engage, labour problems, all the problems that contractors have. And obviously that's particularly significant where the contract expressly deals with concurrency. So when one contrasts what happened in this case, where the contractor's claims were simply put forward as PDF submissions, versus what should happen, it's impossible to interrogate, well, where was the critical path in truth, and what were the causes of delay, as opposed to simply the very specific items that the contractor complained about. Now, my lord, I mentioned the SCL protocol, which my client's expert, Mr. Allen, had mentioned, and I just want to take the court to that document because the contractors hopefully included it in the bundle. So the SCL protocol is a document prepared by the Society of Construction Law. It doesn't have contractual effect. It's a statement of good practice in dealing with delay claims, and it's commonly adopted by tribunals and by courts and other tribunals when considering how the parties have acted and whether what they've done is good practice or not. Now, the relevance of the protocol is it just makes my point about how significant. So I'm so sorry. So I'm in page G82.
That's useful.
It's not the start of the protocol. I'm in chapter 1. And so the protocol gives guidance as to what should happen, and it illustrates the points I'm making. So at 139, still on page G82, 1.39 is a heading program. The form and software for the program should be specified in the tender documents in the contract. Commercially available software should be specified, and in most cases the program should be based on the critical path method. I mean, it says in most cases. I think really only in the most simple case, such as a kitchen extension, you're always going to need critical path analysis to work out, in other words, ascertaining what are the sequence of events that have caused delay. And in order to make a critical path analysis, it's going to be necessary to have some software. Now, the protocol, the SCL protocol, goes on to say at G83, again, it's no more than guidance as to what one needs to do a competent delay analysis. It doesn't have any legal effect as such, but it illustrates the seriousness of our complaint. At 142, the contractor's proposed program should generally be prepared as a critical path network using commercially available CPM, in other words, critical path method programming software. Everyone should have the software. And then at 143, for the contractor's proposed program to be suitable for use as a tool, it ought to be properly prepared so that when a delay or disruption occurs, it can accurately predict the effects. The contractor's proposed program should be provided in its native electronic form to the contractor administrator, not just as a PDF. Using the software, the contractor should identify the critical path, all relevant activities and key interfaces, and the information the contractor requires. So again, this is all statements of the obvious, but it's absolutely essential in any delay claim, whether it's during the project or in litigation, that both parties have the contractor's program in a native P6 form, in other words, with the logic links shown and the critical path shown, and not as a PDF. And although the SCL protocol doesn't spell it out, the mischief that the reference to PDF is getting at is that it is very easy for a contractor to show a very slanted version of events on a PDF, in other words, as a printed saved document without any information as to how they've done that or what changes they've made to their program in order to give a certain effect. And then at 145, still on page G83, it refers
Isn't that when the engineer comes in and determines whether the contractor is fair, honest, and things like that? The engineer plays a role in determining the fairness of what the contractors are claiming, isn't it?
Yes. The point being made, my lord, is that what the protocol is saying, which is as true for during the project as during litigation or other dispute resolution, the point it's making is, well, you obviously need a program in a native form so that it can be interrogated and examined. In other words, you need to see the underlying logic links and so on, because otherwise what the contractor will do when they have a claim, and when I say contractor, it is every contractor in every project, what the contractor will do is they will make changes to their program so that the matters complained of suddenly have some immense significance that if the program were left unadulterated, they wouldn't necessarily have, or contractor delays would be more apparent. So that's why it's essential. And what happened in this case is the contractor's expert said, oh, well, I'm not going to bother with that because he found it so unreliable. I'm going to do my own relatively high level analysis. And I'm not going to take the court to the reports, but they are extremely simplistic, where a delay event is identified and at a very high level superficial approach, the contractor's expert says, well, this has caused a delay from date X to date Y. That's simply not how delay cases are dealt with. But when I say not how they're dealt with, never mind in the TCC, even in the most straightforward domestic adjudication, where the adjudicator just has 28 days, there would be an expectation generally that the adjudicator would look into would insist on the P6 native files so that one could actually see, well, what has actually happened here. And it's very difficult to contest a case where all you're getting is relatively superficial analysis. And like there's a further example. So if I can take sorry, so I've taken the court to 145. At 147 on page G84, still in the SCL protocol, the protocol explains about the logic links. So activities should be linked together by the appropriate logic links, such as finish to start, start to finish, and finish to finish. Those logic links may demonstrate a sequence-constrained critical path based upon necessary construction sequencing, or resource-constrained critical paths taking account of resource constraints or preferential sequencing, and so on. And the point of all of this is that if a delay event occurs, if the contractor provides full visibility as to how they have planned the work and the logic links between things, then they can't cover up their own errors, because one will get a genuine understanding of how an event has caused delay, if indeed it has caused any delay. If the contractor doesn't provide the P6 native files, then it can take out logic links, it can reduce periods, it can make all sorts of changes, and one has no visibility of that. As I say, that one's talking typically about a program with many hundreds or thousands of activities, and if they're summarized I mean, the same software can be used to provide very high-level summaries, but then one's losing visibility of, well, what actually is going on. And it is, unfortunately, we are in modern delay disputes, one is heavily dependent on the software, but that's simply a recognition of the fact that these projects are typically quite complex.
Mr. Moore, Mr. Moore,
sorry.
Mr. Moore, if you allow me, I mean, this is a quick question. I mean, the SCL protocol is just mere guidance, isn't it, for contractors or engineers to use? Is that right, Evan? It's just a guidance.
Absolutely, my lord. But it also has relevance to how experts should conduct themselves in a dispute, a delay claim, because the guidance is intended for both use during the project and in the resolution of disputes.
But is it true a judge could have found the delay from this systematic program software, one things, the notices and the letters, the communication between parties? So it's not the only software, I mean, is the determining factor in how to find delay. And notices can be a vital to these things, letters between engineers.
Well, I totally accept that. I totally accept that.
And one last question. Does the engineers and the employer got access to this software program during the process of building the project?
In this case, we were not provided with P6 native material, although obviously what the protocol is saying is it's better if everybody has it. But on this particular contract, we didn't. And that's why when it came to the litigation, we said, well, so that the parties can be on an equal footing, we want all the materials that the contractor has given to their own experts so that we can interrogate this. But my lord, if I can just deal with the first point, my lord.
Before you proceed on, what is the error that I think you mentioned this earlier on? What is the error that the judge committed insofar as this part of his judgment?
So the appeal, my lord, is that the judge, having found that the contractor was in breach of the court orders, both court orders, the sanction he applied was a cost sanction. So he directed that the contractor not recover costs. Whereas we say, no, the sanction should have corresponded to the nature of the breach and its impact, which was that we were prevented from contesting the delay claim fully because we were unable to do critical path analysis and to see, hence my learned friend's case, all of the 96% of the delay is the employers. Well, obviously because it wasn't a fair fight. If I may deal with your excellency's
so
point.
what should the judge have done?
Sorry, I'm so sorry, my lord.
What order do you want from us now on this particular issue?
So we say, well, this only arises if the contractor's appeal were to succeed, because the contractor's appeal is premised on findings of fact about the expert evidence and the causes of delay. And we say, obviously we resist the contractor's appeal on principle, but that if the court were minded to accept the contractor's points of law on their grounds 1 to 6, that the appeal should nonetheless fail, because the judge should not have reached the conclusions he did on delay, which he would not have done had he rejected the contractor's delay expert evidence, which is what we say should have been the sanction. That was the application we made.
The judge should have rejected the contractor's expert evidence.
He should have disallowed it on the basis that the contractor's expert was provided with key materials, I mean fundamental materials that we were not provided with, so that it wasn't a fair fight. So the order that the judge should have made in relation to breach of the order was that the contractor be debarred from relying on expert delay evidence, and had he made that order, then obviously the only evidence would have been our own, and he would have rejected the claims for delay. The alternative, my lords, is my learned friend seems quite relaxed about the possibility of some further fact finding. Obviously, the alternative is a further hearing that the matter be remitted, and that my client's expert that these materials be provided to my client's expert, and we be given a proper opportunity to fight the case. Obviously, the court would be, we anticipate, reluctant to go down that route, but that would be the only fair alternative to our primary position, which is that the delay case advanced by the contractor should have been rejected because its expert evidence upon which it was based should have been excluded.
That latter option would involve, in effect, rehearing the whole trial.
Rehearing the whole trial on the delay issues, which is a significant part of it. Including
cross-examination of witnesses.
Including cross-examination of the expert witnesses, quite so.
And probably the fact witnesses too.
Well, yeah, quite possibly, my lord. I couldn't rule. Yes, if that. So,
can you tell me this then, Mr. Ward? Sorry to interrupt. Can I?
Go on. Yes, please go on.
Judges have problems during trials every day of the week with late discovery, late applications, arguments about prejudice, and so on. They have to make a decision, usually fairly quickly, but it's based upon their assessment of their impression of the case, who's been constantly in breach, and so on, what the excuse is, and so on. If you're saying the judge was wrong, you're going to presumably point out to some error of principle in the way he approached the matter.
Yes, my lord.
Where do we find that?
Where do we find his error of principle, or me pointing it out in my submissions?
In the judgment.
So,
you can cross-reference it to your submissions if you like. But
the judgment deals with it. I think I took the court to B122, yeah, which is where he has the heading, which is where he starts to deal with it. Oops.
Yes. Where did he? Which is the paragraph where he begins to go wrong?
I'm just directing the tribunal to the relevant page. So he starts at 193, and the key criticism that we make, my lord, well, there's two criticisms. Firstly, that he doesn't appear to acknowledge how significant the P6 programs were, how fundamental they were. I do want to deal with Your Excellency's point, my lord raised about, well, isn't it also possible to look at the notices and so on? I do want to come back to that before we get too far away from it. But in terms of my complaint of principle, the learned judge didn't pay regard to the significance of this material, but in doing so, he appeared to blame not just my party, but my client's expert and his lack of aggression or determination in making a fuss. And we say, as a matter of principle, it is never the correct start point of what sanctions should be applied to look at how an expert responds. And the reason for that, there are two reasons why that's wrong. Firstly, because the sanction to apply to a party in breach shouldn't be determined by how angry or cross the other party is, because parties should be encouraged to cooperate with one another, not to scream when someone's in breach of an order. They shouldn't be rewarded for being more aggressive. But secondly, perhaps more importantly, an expert's response to a breach of an order is always wholly irrelevant, because the expert should be wholly outside the detail and the fight of the litigation. Mm-hmm. Once an expert starts involving themselves in breaches of an order or enforcement of an order, they can only do that if they've completely lost sight of what they're supposed to be doing, which is assisting the tribunal with independent evidence, separate from the exigencies of litigation. So, my lord, the passages are so paragraph 195. So if we just drop a page to B123, so it's still in the same topic. The learned judge quoted Mr. Allen as saying that he'd been unable to prepare a full time impact analysis. It remains even to this day impossible for me to conduct a full time impact analysis for the core events that are relied on. I'm still not in possession of the P6 native format programs. And those are the materials that were ordered to be disclosed and which had been given to the contractor's expert. Mr. Allen pointed out that all but one of the pleaded delay events originated prior to October 18, and you can see that from my learned friend's note that he handed up overnight. There's a reference to one of the events is after. And then this is the point that where our criticism of the learned, our respectful criticism of the learned judge really starts. He says it is notable in my view that from the outset, notwithstanding the potential significance the P6 files had for the report on delay, Mr. Allen did not request the lawyers acting for Panther to insist on the provision of these files because of their direct relevance to the delays that had beset the project. Now, we say that's obviously wrong. The materials are not potentially significant. They are fundamental to any kind of sophisticated delay analysis. And without them, one has not just an inadequate analysis, but one that will inevitably be misleading because the contractor chooses exactly how they present the material, and the employer has no way of interrogating that or seeing what changes the contractor has made to their actual planned intention. So when the contractor says event X caused critical delay, it's nothing more than just assertion, and we have no way of challenging it. So there are fundamental importance. And the judge is here saying that what's significant for him is that my client's expert, who should be independent of the litigation, didn't make more of a fuss about this. Now, I think it's explained elsewhere that Mr. Allen was under the assumption that, in fact, it says in 197, this may have been because I'm reading 4 lines from the bottom of 197, this may have been because Mr. Allen, assumed that if he did not have the files, Mr. Single, who is the contractor's expert, would also be without the files. But he could not and ought not to have been sure about that, given that the files had plainly been used in producing the updated programs. So again, the judge appears to be, in choosing what to make of this, appears to be putting it all on Mr. Allen, who's doing nothing more than his job as an expert. And doing his best, other than noting that he hasn't got the material he needs.
Well, sorry, I beg your pardon. So what should the judge have done in this case, in this particular instance?
Well, what we're saying, my lord, is that given that the contractor and the contractor's expert had these fundamental materials and we did not, and given that the contractor was in breach of 2 court orders requiring them to produce it, that the correct sanction was to exclude the contractor's delay evidence because we were not in a position properly to contest it. Because what the contractor was putting forward was not what would normally be understood as delay analysis. In other words, a critical path analysis based on software where the delay events are applied in an open and straightforward way that the employer can then interrogate. What the contractor was putting forward was their own selective determination of how they want to present the case. Hence, my learned friend can say, oh, well, the employer was responsible for 96% of the delays. Well, of course, if that's how it's been done. I will at this point just take up Your Excellency's observation that, of course, when as analysing delay, the court can and will also have regard not just to the programme, but also contemporaneous records and documents. But the point we make is, as we've seen, I think, from my learned friend's case on notice, what the contemporaneous documents tend to say is, you're late with this information, or we haven't had this information. Now that is a record of a delay event or of a breach or failure to provide something. But what that doesn't tell one is, but what are the consequences, if any, of that? Because of course, often an engineer may be late providing information. The contractor may not be ready for the information, or contractor may be having other problems of their own, or the delay may be very short. The point that arises, yes, but what are the actual consequences of that? And at that point, it's impossible to do an analysis without a critical path software, in other words, the P6 program files. So what did happen in this case in the project, as is evident from the judgment, is the contractor submitted a series of extension of time claims, but as Mr. Allen observed, these were typically in PDF form, so they were deliberately presented in a way that prevented interrogation. And an analogy that I would suggest is, if one had a case where the employer was alleging defects such as defective wells and served notices saying, well, we're not happy with your wells, but refused to hand over their analysis or their weld reports or x-rays or cutout welds and so on, then yes, you've got some sort of contemporaneous record, you've got some evidence, but it's impossible to have any kind of proper analysis of the extent or nature of the problem. And that's the analogy here. Of course, a contractor can always say, well, this information is missing, and that's causing us a delay, and that's causing us a problem. But that doesn't necessarily mean that we're responsible for 300 odd days out of 325 days of delay. And as I say, it's no coincidence that the contractor, having deliberately failed to comply with 2 court orders, of course the contractor is then going to have a highly successful delay claim.
Isn't the judge, you say the judge was criticizing Mr. Allen's reaction in some way? Isn't the judge simply using Mr. Allen as an indicator of how critical he thought these documents were? And the fact that Mr. Allen seemed content in paragraph 197, I think it is, to work on the basis of what he had, and didn't ask his solicitors to make a further urgent application to the court. The judge wasn't entitled to take that as indicating that they were not so fundamental, that it was not so fundamental as to justify excluding the evidence altogether. And that's really the conclusion he came to, I think, in paragraph 200. And I mean, we may or may not have come to the same conclusion ourselves, but can one really say the judge reached a decision that no reasonable judge could have reached on the evidence, which is what the test is, isn't it?
I think that is the test. Thank you, my lord. I mean, in fairness, the judge did give permission to appeal on this ground, so far as that's relevant. The judge obviously had recognised the legitimacy of our complaint. So Sir Richard Field dealt with our application for permission. So paragraph 200, which is at B1124. He says at 200, he says, Panther had the opportunity to raise the unavailability of the missing P6 files when Mr. Allen and Mr. Clark began working on the first delay report, and no urgent protest was raised after the copies of the files that were made available on 22nd of August were discovered to be unreadable. Instead, the decision was made to continue to rely on the 2 reports that had been served. I mean, the difficulty with my lord's observation, we would respectfully suggest, is he's not saying that the material was unimportant, because when one looks at the evidence of Mr. Allen, and when one looks at the SCL protocol and thinks about what these materials are showing, they obviously were of fundamental importance. And if the learned judge took the view that they were just another bit of evidence that one could take or leave, that we say, well, that's clearly not the case. They are of fundamental importance, and hence we read paragraph 200, or we suggest a natural reading of 200 is that the judge considered that it was Panther that was at fault for not making more of this issue at the beginning of the process. And we say, well, Panther did everything they could. We made repeated application to the court. We identified these materials in the red phone schedule, which was part of the disclosure exercise. And when we served our expert evidence, it made clear how we had been prejudiced. And the result of the case, of the learned judge's discretion, of course, it's highly tempting for a trial judge trying to resolve a party's dispute to allow evidence to be adduced. But we say that if one stands back and considers the nature of the material and its consequences, it was in effect on this issue a mistrial, because we were denied the opportunity to contest the case on the technical basis, and it's impossible to explain what happened in any other way.
Can I just ask, because I need to read through again these paragraphs of the judgment, but did you your clients at any time after the breach materialized, the failure to produce the material, did they ask for an adjournment? Did they ask to discharge the trial date until the material was put forward, or anything of that sort?
No, my lord. So that's the so the sequence was the trial was in September 2021, and my lord will see that the corrupted files were provided, unreadable files were provided in August 21, and the issue was raised. We didn't ask for an adjournment, but the my predecessor, the advocate for the trial, asked for the expert evidence to be excluded at the trial on that basis. So the answer to my lord's question is no, we didn't ask for an adjournment. But I would point out again that the lack of aggression my client shouldn't be criticised for not having done more to complain. Bearing in mind that this was quite a complicated, quite a heavy case going into a relatively short trial period, that in the immediate run up to a trial, what typically lawyers are obviously trying to prepare their openings, their cross-examination and all the rest of it, and not necessarily resource to start making heavy applications. But obviously once the trial was underway, it became apparent what a mismatch there was as between the two experts. But the answer to my lord's question is no.
Yeah, what happened? They didn't comply with the court order to produce. And what happens? What happened after that when they didn't comply with the court order?
So there were two court orders, my lord, and they didn't comply with either of them. And they then they provided some material late in August, out of time for compliance, and the material was unreadable. And so when the trial started, the materials hadn't been provided. Hence, Mr. Allen's evidence, as reported by the judge, that even during the trial, he still hadn't had this essential material.
So they were not penalized for not complying with the court order.
So the penalty that the court imposed was simply that they don't that the costs at paragraph 202, that the contractor's expert evidence that they be prohibited from recovering the costs of it. And we say that is recognizing the seriousness of the breach, that it did have consequences, but it doesn't meet the nature of the problem, which is that in circumstances where the case, as mentioned earlier, was essentially a delay case, it's proceeded simply on the basis of the contractor's assertions as to what the delays were, rather than any kind of independent evaluation of those. Hence the inevitable outcome that the contractor recovered an almost 100% extension of time, subject obviously to the matters in Madhani and Friends appeal. So, my lord, that's all I was going to say on the on ground one, which is obviously would fall away if the contractor's appeal failed. Conversely, if the contractor's appeal succeeds, it appears to be now being suggested by my learned friend that there should be some further factual investigation, and in those circumstances, we say, well, it would only be fair and reasonable for that investigation to be done properly, with proper disclosure and both parties on an equal footing. So, my lord, unless I can assist further, I'm going to move on to the other grounds. So the other grounds are just a miscellany of, I hope, relatively short points. There are 4 of them. I'm just going to summarise what they are. Just to remind the court, what happened with this project is that the contractor abandoned the site. So the contractor never finished the work. They repudiated the contract. They invaded the site, having rescinded the contract, which obviously caused my client problems. The termination was in about November 2019, and we then, I think we completed the project on the 1st of May 2020, but with different contractors. So there was effective repudiation of the contract. We exercised our contractual right to terminate when the contractor abandoned the site, and we then had to employ new contractors to complete the work. And obviously that gave rise to further delay, post-termination delay, and additional costs. And these 4 grounds of appeal arise out of that. And there's no appeal from the judge's finding that the contractor abandoned the project and so on, and we were entitled to terminate. The 4 points that
So
are as
the
follows.
abandonment by the contractor, was it according to the to the contract? Was it proper notice given? And
It was abandonment. I don't think the contract allows them to abandon the project. I mean, they unlawfully abandoned the contract, and we, the employer, were
That's your
entitled.
contention.
Sorry, my lord.
That's your contention. The contractor
No, this
must
was
have.
what the judge found.
You're not paying me. You're not recognizing my request for an extension of time. Blah 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 blah. And therefore, I'm going to leave you. Isn't it? I don't know. I don't know what the law, but what actually happened.
No.
They just left. They just left the site. They just left the site. Is that what happened?
They abandoned the project, and the judge found that they had abandoned the project, and that we were entitled to terminate, and that none of that is challenged. So that's completely independent of extension of time and all the rest of it.
Okay.
So that's those are findings that are not subject to appeal. So the contractor caused us these additional problems of the further delay from November 19 to May 2020, as well as the delay they're responsible for prior to November 19, prior to termination, and some miscellaneous cost items. If I can just summarize what the 4 grounds of appeal relate to. Ground 2 is our claim for loss of rent up to termination and from termination to completion. Ground 3 is our entitlement to recover professional fees. And so grounds 2 and 3 are quite similar. What we say is the liquidated damages provision preserves the right to make such claims. Ground 4 is a relatively modest item where we seek to recover some legal costs that we incurred in dealing with the contractor's conduct. And ground 5 is a claim for the loss of the benefit of the contractor's guarantee as a result of their repudiation of the contract. So I'll expand on those briefly. I do hope. Sorry, my lord.
I thought they executed the bond, the performance bond, performance guarantee, didn't they? They presented.
There's a bond, which is money. There's a bond in the sense of money, but there's also a 10-year guarantee with nothing to do with the performance bond.
Okay, the 10-year guarantee you're talking about. Okay.
10-year guarantee. So the case in summary on that ground is ground 5, which I'll come to last. Our complaint is because they didn't complete the work, we don't have the benefit of that 10-year guarantee, which the judge upheld. That's a quantum only issue. My lord, can I just mention something that when the court comes to review the judgment, there are a couple of...
Mr. Moore, if you allow me, I mean, for the loss of the guarantee related to what? To the building, to the substructure, superstructures, or the machines, the AC, fire, fabrication? What exactly? Is it everything? You lose the guarantee for everything, or certain things, or?
I hate to admit it, but I don't actually know exactly what state the building was when they terminated. So I'd have to take instructions, Your Excellency. But in summary, the way we put it is some of the work was incomplete and had to be performed by new contractors. I suspect it was a mixture of services and construction work, but I would need to take instructions. But what we say is that work that was done by others did not have the benefit of the contractor's guarantee. And the judge upheld that in principle, but we're just contesting how he assessed the value of that claim.
I'll go on. Okay, thank you.
I will have to take instructions on exactly what was outstanding at that stage. So I was just about to make a point, my lords, that when reading the judgment, there are a couple of occasions when the judge sets out what the contractor was contending for, but he doesn't make it explicitly clear that that's what he's doing. So when you read the judgment, it looks as though the judge is upholding the contractor's case, but it's then apparent from the following passage that he's just setting out what Mesk was arguing for, and then he sets out his view. So for a couple of these items, some care needs to be taken. So the first item is ground 2, which is our claim for general damages for delay. And as I say, the claim is in relation to delay prior to termination and after, in circumstances where we have not had any compensation for the delay caused by the contractor as a result of the termination. The claim is for both. Now, we rely on amended clause 8.7, and we just need to look at that. So the original 8.7 is at C45, so it's part of the FIDIC contract terms. So page C45, this has been amended, but I'm just showing the court so that one can see how the amendment works. Second paragraph of 8.7, so it's referring to delay damages, which we've looked at a little bit yesterday. Second paragraph of 8.7, these delay damages shall be the only damages due from the contractor for such default or failure to complete within time, other than in the event of termination prior to completion of the works. These damages shall not relieve the contractor from his obligation to complete the works. So that's what the original document says. And then we need to turn to the amendment, which is at C157. C157, amendment to 8.7 delay damages, delete the first sentence of the second paragraph, and at the end of the final paragraph insert, and are strictly without prejudice to the employer's other entitlements under the contract, and shall in no way preclude or restrict the employer's ability to bring a general damages claim. Now, just to be clear, we're not seeking double recovery. We acknowledge that we don't get compensated twice, but this bespoke amendment that the parties have agreed allows my client to bring in an appropriate case general damages for delay. And then it goes on to say, and this is going to be ground 3, in addition to the delay damages, the contractor shall fully compensate the employer for any additional fees that the employer is required to pay to the engineer or any other third parties arising out of or in connection with the delay. But I'm dealing with the first sentence, which is the without prejudice to the employer's other entitlements and shall in no way preclude or restrict the employer's ability to bring a general damages claim. The learned judge considered the construction of this clause at paragraph 94 onwards, which is at B77. Under the heading Other Liquidated Delay Damages provided for in subclause 8.7 of the contract, the sole remedy up to the stated maximum for all claims for losses alleged to have been caused by delay in the period from the commencement date down to the termination of the contract. And there's some consideration as to whether of triple point. Well, we say triple point is simply relevant because the provision here is relatively unique and not one that's considered in triple point, which is the reference to without prejudice to the employer's ability to bring a general damages claim, makes consideration of other cases with no such provision irrelevant. At 95 on page B77, para 95 of the judgment, the learned judge held in advancing these submissions, Panther relies on express stipulation in subclause 8.7 that the delay damages are strictly without prejudice to and shall in no way preclude or restrict entitlement to bring a general damages claim, and the total amount due under this subclause shall not exceed the maximum amount of delay damages. And then he sets out the contractor's contrary position, and then at page B78, paragraph 97 of the judgment, it says, I find this question of the construction of clause 8.7 a difficult one. As has often been said, liquidated damages are designed to avoid what otherwise would be could be the difficult task of establishing the quantum of loss consequent on delay, and they thereby confer a benefit on both parties. The purpose and function of delay liquidated damages provided for clause 8.7 therefore points strongly in favour of method construction of the clause. On the other hand, the exclusionary words in clause 8.7, these liquidated damages shall in no way preclude or restrict the employer's ability to bring a general damages claim, are of a general nature and accordingly support the construction contended for. Then he holds, in my opinion, clause 8.7 is concerned with delays occurring pre-termination, even though they may result in a loss that only crystallises post-termination. And after anxious consideration, I've come to the conclusion that the exclusionary words read in context contemplate claims for loss that does not result from delay pre-termination and claims for loss that results from delay that occurred post-termination. I personally don't quite understand those last two lines. The learned judge goes up.
I was about to ask you to explain what.
Please do not do so. I think that, I mean, he then gets on to say at 98, I follow as I'm not persuaded by Panther's submissions that the exclusionary words permit a claim for loss suffered post-termination that is the result of the delay that occurred pre-termination and or where the contract is terminated on grounds other than for delay. He then goes into quantum, which I'll come to momentarily. My lord, we say that the clause is straightforward. It is certainly an unusual one. So if we return to C157 rather than trying to puzzle out precisely what the judge's reasoning was, I think the most significant part of the judgment is the judge's acknowledgement that he found the construction of clause 8.7 a difficult one. We say, well, it's a slightly unusual outcome, but 8.7 is expressed in such explicit and clear language. The words "and shall in no way preclude or restrict the employer's ability to bring a general damages claim" is straightforward. What the contract envisages is the contractor suffering other losses, sorry, the employer suffering other losses, not compensated by the delay damages for whatever reason. And the two examples that arise under this are ground two are losses caused by delay, not compensated by delay damages up to termination. And in addition, the further delay as the employer instructed other contractors to complete the project between November 19 and May 2020. And we say we are clearly entitled to compensation for the post-termination delay where there is no liquidated damages provision. Obviously, we should recover compensation for delay in the period from termination to completion as quickly as we could finish the project without the help of the contractor. But in addition, we say that the words are sufficiently clear as to include losses not compensated by delay damages. To be absolutely clear, we're not suggesting we should recover compensation twice.
How do you work out? And when you say you can recover damages on top of delay damages, if the delay damages don't fully compensate you, is that what you're saying?
Yes, my lord.
You're saying that you then basically disregard the delay damages altogether and a fixed sum per day and have to prove your loss from scratch. Otherwise, you don't know whether the delay damages have compensated you.
Well, my lord, the answer is that the delay damages provide a start point, and then if the employer feels that that it suffered some general damages that are not compensated, then it has the additional exercise of proving that loss. But obviously the start point of delay damages, as everyone acknowledges, is to avoid the need to prove loss and to avoid the additional costs and difficulty of trying to prove a loss. But
you go for your delay damages up to the 10% maximum, whatever it is, and then for the period after that, you prove damages at large.
If we were able to do so, and I mean, bear in mind, my lord, it's not uncommon under civil code systems for the court to adjust compensation where delay damages are inadequate, or to adjust them where they're. But my lord, we say that's what it means. It's very, we say it makes perfect sense in the context of post-termination losses, where there is delay that is, as it were, outside the scope of the contract, and it's an entirely sensible preservation of the employer's right to recover its ongoing delay costs whilst it completes the project.
Mr. Murphy, if you allow me, Mr. Murphy,
I'm
allow
sorry,
me.
Your Excellency, of course.
This point of the delay, damages, it should not be succeeded unless you succeeded in the previous point, where you shift, the burden of delay on the contractor side, isn't it?
My lord, that is my learned friend's point.
Yeah.
So that's my learned friend's case, amongst others. But we say there's two answers to that. In terms of delay post-termination, of course, that is the contractor's responsibility, because the court has found, and it is not challenged, that the contractor abandoned the site, and that is how the contract came to an end. So there is the delay case and my learned friend's grants have no bearing on the period between November 19 and May 2020. So that is of our claim for loss of rent. That is 3.5 million dirham. My lord, your Excellency's point about the period up to termination, we say what the contract provides for is that the contract is responsible for completing the project by an agreed date, and if they do not do that, it is no role of the tribunal or the court to inquire as to the underlying reasons for their failure, whether they were caused by prevention or neutral events or contractor disorganization, whatever. The losses flow from the fact that the contractor has not completed by the date that it promised to complete.
It's based on the breach anyway, not delay only.
Sorry, my lord?
It's based on the breach, not on the delay. The breach of any kind, yeah.
The breach is failing to complete by the agreed date as set out in 8.2 and 8.4, which deal with the contractor's obligation to complete on time. If they don't complete on time, whatever that time is, then they are liable for the financial consequences of that breach of contract. Why they didn't complete on time is irrelevant for these purposes, just as it would be in any case if somebody agrees to sell somebody a car or any other contractual obligation. The reason why they are unable to perform does not itself discharge or affect their liability for breach. And that's
but in this case, what is the contractor's defense to this, that there was a delay or there was a breach by them? What did they say? What? I'm sure I can't remember what I read in the pleadings, but I'm sure they put the blame on you for them not completing the job.
Of course. So they. Sorry, there's two different issues. Do you mean in terms of the termination? Yes, their case at trial was that they were entitled to suspend, I think, or that we terminated wrongly. But that case was rejected by the judge. So, and that's not the subject of any kind of appeal. Yes. Okay. So, my lords, you're quite right. There was a big issue at trial as to who had terminated or who was entitled to terminate, and those issues were decided in my client's favour, and that's the factual premise of the discussion now. So, but there's obviously two different questions under this 8.7. One is, well, why did the contractor not finish on time? And we say that's irrelevant, subject obviously to my learned friend's appeal on ground, his appeal. Why the contractor finished when it did is irrelevant to their liability for finishing late. So that's question one. And then question two is, well, how did the contract come to an end? But there's no such question, because that's already been decided at the trial and is not the subject of any kind of challenge by either party. So we say we say that is all straightforward, and it's just a question of the entitlements that arise, and the claim is put on the basis of our expert evidence, which the judge then helpfully summarized. If we just go back to the judgment. So I'm on page B78, which is where he addresses the subclause 8.7, and at paragraph 100 on B78, he refers to Mr. Paul, who is the employer's expert from Savills, and he refers to loss of revenue from sales as a result of the delay. And at paragraph 101, an alternative, much lower calculation based on loss of rent. And the total loss of rent at now on B79 is summarizing Mr. Paul's evidence that the loss of rent was in total 9.1 million. And for my lord's reference, the calculation is at F75 of the of the bundle. And what Mr. Paul has done is he's made a calculation of what loss of rent was caused in the period of original delay. In other words, from the original completion date to termination, which was a period of about a year, because you remember that the overall delay is about 320 days. Mr. Paul's done a calculation of 5.6 million dirham. This is the figure at the bottom of page B78 for the 12 months following the original completion date to termination, and then a further calculation which is 3.45 million dirham for the delay loss of rent suffered up until May 2020. I should point out that yes, to get 9.1, it's 5.6 plus 3.4 odd. I'll just show it on the graph at F75 so that you. So this is F75. So this is Mr. Paul's expert report referred to at paragraph 101 of the judgment. And Mr. Paul shows his two scenarios: the loss of capital of sales as a result of the impact of the contractor's conduct, and then secondly the rental scenario. And his calculations here are, so for a year from completion to termination, so that's the contractor delay, is 5.6 million. And we would say, well, you obviously have to give credit for the delay damages that are paid. But in addition, we say the employer is entitled to their loss of rent from termination to May 2020, which is in the sum of 3.4 million dirham. And we say that there's no conceivable reason why we should not be compensated in that way, given that the contractor abandoned the site and directly caused us that loss. So, my lord,
the judge didn't make any finding in your favour on the evidence, did he?
That is correct, my lord. I'm sorry.
If you look at paragraph 102, he goes as far as saying if Mr. Paul's reasoning is accepted, he doesn't actually accept it.
I accept that, my lord.
So what do you ask us to do? Yet another remission.
Well, we would invite the court to accept it. I mean, it's obviously not straightforward, because the learned judge, he acknowledged that clause 8.7 is not, he found it a difficult question. It's obviously, we say, a straightforward legal point, but obviously the court has a discretion to remit the matter for further determination. But we would invite the court to adopt the figures as set out in the judgment. But I do acknowledge, my lord, and I didn't mean to suggest otherwise, that the judge does not formally himself accept these figures. He simply sets them out.
Yeah.
I think that at paragraph 102, my lord, just to be clear, where he says Mr. Paul's scenarios depend vitally on the delays to the works that occurred in the period to November 19, when the contract was terminated. What I tried to show when I just pulled up Mr. Paul's actual evidence at F75 is that one can see how he distinguishes between those. So in other words, if the court took the view that the claim after termination is valid, which we say is obviously the more straightforward, much stronger argument, that the post-termination claim, we do have from Mr. Paul his analysis of the loss of sales, the loss of rent at least, from the period November 19 to May 2020, and that's the sum of 3.45 million dirham. So whilst I acknowledge my Lord's observation, and whilst the judge doesn't actually mention that figure of 3.45, it is very clear from what he does say that the 9.1 is in part 9.1 million is in part up to termination. Delay is caused, we say, by the contractor up to termination, and the balance of 3.4 is the loss of rent caused by delay. There's a further table, my Lord, that if one turns to F69, it's still in the Savills report. He does a comparison of how this is what was anticipated, and then two pages down at F73, this is still in the rental scenario. At F73, he shows the actual. So obviously everything's happening later because it's not finished till May. And as I understand it, that is then how he calculates his conclusion, is by comparing those figures. In other words, there's a delay in the ramping up of rental income because of the delay in completion of the units to May. And we say, well, that at least should be a straightforward claim in principle, and in fact a straightforward claim in terms of quantum. My Lord, moving. If I can assist the court further, I propose to move. Yes, my Lord.
Mr. Mott, assuming that we decide in your favor on this point, I mean, there's going to be some dispute, which is the damages to be awarded, isn't it? What happens there? Do we as a court of appeal decide on that, or fix another day to determine the damages to be awarded, or send it down to the court of appeal to assess the damage, to agree or not to agree to your experts' opinion?
I'm so sorry, my Lord's audio was cutting out slightly, but I think you were asking me what
Can you hear me?
I can, my Lord. It's just very slightly interrupted. But I think my Lord was asking, what does the Court of Appeal do should it accept my point of principle? And
Yes.
what I'm suggesting, my Lord, is, well, obviously there's two possible, or a range of possible outcomes. One is that the court accepts my primary case, that the employer is entitled to any delay damages insofar as it's entitled to general damages for delay, notwithstanding the delay damages provision, but given the clear wording of the amendment. The secondary position is, at the very least, we must be entitled to the delay from termination to completion. And on the latter case, I've identified the material.
No, the question is, how do we determine the quantum, assuming we are in your favor?
So, my Lord,
how do we decide? Yes, please.
So my preference would be, if the court felt able, that it would adopt the values in the Savills and Mr. Paul's report as set out in the as referred to in the judgment, whilst acknowledging that the judge did not make any. My Lord Glennie's point, that the judge did not in fact make any findings in relation to those. If, on the other hand, the court feels that a further determination must be made after further inquiry, then the matter will have to unregrettably have to be remitted back to the judge of first instance. I mean, they're not insignificant sums, but
Was there some evidence led on the other side contradicting Mr. Paul?
My lord, there was a report from. Yes, is the answer to my lord's question. I think there's a report from Land Sterling.
Right.
So that's I think the author of that report does I think a similar exercise. It may be my learned friend is better suited to take the court to it, but to this is a F593.
Yeah.
And he does. I don't purport to understand his figures. I found the Savills report much easier to follow, but he comes up with a. This is at F594, which is his summary page, and he comes up with competing values. So, funnily enough, his values are all lower than my experts' values. What I don't know is why the contractor's case wasn't referenced in the judgment. But the answer to my lord's question is yes. There was competing property expert, valuation expert evidence, and no determination as such in the judgment. And
So
the
wouldn't
judgment.
shouldn't we just send it down to the trial judge and let him decide on the quantum?
Well, I
decide?
suspect that in reality that is what the court. But I'm nonetheless asking the court to accept the figures that are in the judgment. But I fully acknowledge the limitations, the reasons why the court might hesitate to do so. Thank you, my lord. So that's that item, and I do acknowledge it's not an insignificant sum of money. So if we just quickly look at ground 3, so this is, I quoted it when I was looking at ground 2. So this is the claim for for engineering fees. So if we turn to page C157, which is the amendment to 8.7.
Sorry, see what?
C157, my lord. So it's the contract, and it's the party's amendments to the contract. It's the passage I just quoted in relation to ground 2.
Yeah.
But the last sentence of the amendment, where it says, in addition to the delay damages, the contractor shall fully compensate the employer for any additional fees that the employer is required to pay to the engineer or any other third parties arising out of or in connection with the delay. And the learned judge dealt with this at 263. So this is if we turn to B144. So B144 in the judgment, paragraph 263, the learned judge refers to my client, the employer's claim for engineering fees, and the heading is in fact MESC on engineer supervision fees. And
What does that mean?
I'm so sorry, my lord.
I wondered what that heading meant.
So he's setting out the contractor's case on my client's claim, although, as I indicated earlier, there's a slight tendency in the judgment to set out points which are the parties' propositions. I mean, in fact, at 263, he's setting out my client's case as well as the contractors. But the argument is similar to the point on the delay damages, but we say our case is yet clearer in circumstances where amended 8.7 specifically it specifically alludes to the engineer's fees. So we say fees pre-termination are recoverable up to termination in circumstances where the contractor is responsible for the delay, subject, of course, to my learned friend's appeal on that. And secondly, that we're entitled to the fees post-termination, given that they are direct consequences of termination and they're an inevitable consequence of the contractor wrongfully abandoning the site. Now, the principal issue is in relation to this point 263A, which concerns the period prior to termination. And the court disallowed the employer's claim on the basis that the delay was caused by the employer. So he says, the learned judge says at 264, I accept submission A, which is for the delay for the period November 18 to October 19. And accordingly, he disallows the item, which is relatively substantial. And we say, but it doesn't matter how the delay comes about is not part of the inquiry. That the contractor is responsible for the delay, as the judge found, and therefore they're responsible for the ongoing professional costs, given the very clear wording of 8.7, and given the contractors. The fact that the contractor is not entitled to extension of time. My lord, that's all I wish to say about ground 3. Ground 4 is also relatively straightforward. It's dealt with in the judgment at paragraph 260, which is B143. What happened was that the contractor, having abandoned the site, then sought to occupy it in order to prevent the employer from proceeding with the project. In other words, they sought to hold the employer to ransom, and in consequence, my client incurred legal costs, including the costs of obtaining relief in the UAE courts in Dubai in order to have the contractor removed. And we say that those costs are part and parcel of the costs of termination and the contractor's breach of contract. And the judge upheld some of our legal costs, including costs of taking legal advice in relation to the contractor's conduct. But the court goes on to find, so I'm now on B144, the end of paragraph 261 of the judgment. The judge found, in my opinion, costs incurred in advising on and seeking relief in the onshore Dubai courts in respect to the site invasion are not recoverable, because in incurring the same, Panther ran the risk that it might not succeed in those courts, or that the Dubai court in question would be of the opinion that there were other good reasons for not awarding Panther its costs. And we say, well, we're entitled to our losses naturally flowing from the contractor's breach. And if we had to incur legal costs, just as that there are numerous circumstances in which a party incurs legal costs or litigation costs as a result of another party's breach, and the ordinary position is that those are that's expenditure of a kind that is recoverable as damages for breach of contract. And we are out of pocket, and there's no reason.
When you got the order from the court to remove the contractor, didn't you seek for cost at that stage? There's an action by itself at the Dubai courts. Don't you get some costs for the?
My lord, I have to take instructions on what the outcome of the order was in the
Dubai,
in the Dubai
onshore court. you would have got damages cost already at that stage, wouldn't you?
My lord, I just have to take instruction on that. But as I understand it, we didn't get our costs, and but nor do we have any. I don't have any indication as to why we didn't get them. But
the reason you didn't get them, if you didn't, could be quite important, because maybe the court said the action was unnecessary, or maybe all sorts of things, which would go to the question of whether you should recover them as damages.
Well, that's a very legitimate point. I apologise. I will just have to get clarification from that.
And another difficulty is like you're asking one court to assess a business that happened and done within another court, another system, so might have another evaluation, which not before this court. The tools is different, maybe.
I appreciate that point, Your Excellency. I think we would say that nonetheless, we are this contract and breaches of it and the remedy for breach is subject to the jurisdiction of this court, and it's entirely reasonable and required that we bring our claims for losses in this court. Well, I'll have to come back on the penultimate point as to why we didn't get the cost in the court. I do apologise for not having that information immediately to hand. If I can move on to my final ground of appeal, which is the in relation to the warranty. I did briefly explain what that related to when I was summarising what our appeals were. So still on page B145, there's a heading at paragraph 268. MESC on other general damages. So again, the heading is potentially slightly confusing because it's actually setting out the employer's case first.
Sorry,
paragraph 268, my lord.
I see.
And to be clear, the court accepts the principle of this claim, which is a point of some potential interest. If I may just read from the judgment at 268. In his first report, Mr. Allen, who was our delay expert but also dealt with quantum, Mr. Allen sets out his personal assessment of the prospective general damages to which the employer may be entitled as a result of the termination. In particular, he proposes a figure of dirham 806,631 to compensate the employer for the potential lack of the benefit of having a 10-year latent defect period obligation owed by the contractor. And then at 269, he sets out MESC's position, although he doesn't make clear that's what he's doing. But MESC contend that, put simply, Panther has no legal or contractual entitlement to any such damages. This is an entirely speculative figure. So 269 and 270 of the judgment on B145 is summarising the contractor's position. So to be clear, the contractor abandons the site, wrongfully terminates. We lawfully terminate, and we become entitled to compensation for our losses caused by that termination. Because the contractor abandoned the project, we lose the benefit of their liability over the following 10 years for the work that they didn't complete. Now, Mr. Allen did a calculation of 806,000 dirham as referred to at paragraph 268. He made that calculation based on 2% of the original contract sum, and that's explained by the learned judge at B146. At paragraph 270, he acknowledges there is an appreciable risk that the employer could suffer future loss, given that the replacement contractor and newly engaged subcontractors have not bound themselves to a 10-year latent defect guarantee warranty that matched the guarantee warranty to which the contractor, MESC, had committed itself. But then he makes the point, in my view, that risk would be in respect of the work done post-termination, So he goes on to criticize Mr. Allen for assuming that the contractor at MESC wouldn't honour their guarantee in relation to the work that they had done up to termination. So Mr. Allen's figure was 2% of the whole contract price, 2% being nothing more than an informed assessment of what sort of allowance one should make against the cost of having to repair defects. And we say over a 10-year period that's a totally the figure of the sort that one would expect. There isn't data as to what sort of costs one spends on correcting defects and so on over a 10-year period, but a small percentage.
It depends.
It
depends how good the work of the contractor is.
It would.
If the contractor didn't do a good job, a lot of defect correction that he has to do. But if he's done a good job, most probably it's zero. So it's very subjective, dependent on what.
And obviously
And
dependent also on if they've installed.
Yeah.
If one thinks of the sort of things that go wrong, it's often going to be potentially the M&E and plant and so on, and it's going to depend on the products that their subcontractors and suppliers have installed. I think
also depends on the contractor who completed the job. You know how well he completed the job.
Right.
That's a problem. Okay, thank you.
But my lord, the point is, the judge accepted that there obviously is a risk of defects arising and a risk of loss to the employer as a result of the contractor not being available to not warranting that work. The fact that it's difficult to make that assessment is not a reason for not making an assessment, and the judge is obviously right. We respectfully suggest the judge is obviously right about that. It is difficult to quantify. He says in terms, it is of course difficult to quantify the loss represented by this risk, but that is usually not a reason for a court declining to do its best to arrive at a reasonable figure. I should observe that this is obviously quite a common sort of claim, and it is very helpful to have any learning on what the right approach to it should be. But we say Mr. Allen's approach, which the judge to some extent adopted, of calculating a small percentage of the value of the work, makes sense absent any other special factors or better information. The point of appeal, for which the learned judge gave permission, is that when the judge disputed Mr. Allen's assumption that the percentage should be applied to the whole contract sum, as I've indicated, because the judge took the view that this contractor, MESC, will come back if there are defects in its work, in the work that it did, and that the claim, therefore, can only relate to the element of the work that the contractor failed to do because it unlawfully abandoned the site. So that's why the judge changed the analysis. Instead of using 2% of the whole contract sum, for the reason stated, the judge didn't accept that the whole contract sum should be used, and so he says, in substitution for Mr. Allen's figure, I award 3% of the figure that Panther is going to receive after the adjustments I'm ordering in respect to the additional completion costs resulting from termination of the contract. And what the judge means by that is that he awarded not 2% but 3% of the additional cost of completion. So in other words,
was the cost of the work not covered by the original contractor's guarantee?
I'm sorry, my lord, I didn't hear the first part of the question.
It was 3% of the additional sum done by other contractors, which is not covered by the original contractor's guarantee.
Well, yes, my lord, but as put like that, it's slightly ambiguous. What the difference is, what the judge has done is 3% of the extra over.
Yeah.
And we say it should be 3% of the remaining cost, not the additional cost, but whatever cost was left. So if the remaining cost was, let's say, I can't remember the figures, but if the original cost was, there was another 10 million left to do, what the judge has assessed is it's 3% of the extra cost of having to employ a new contractor, which becomes a very small sum. And we say, no, it should be a percentage of whatever work was done by replacement contractor. So we say Mr. Allen was in the right area when he said 2% of the contract sum, but we accept that it should probably be a percentage, whether it's 2 or 3. Obviously, we would prefer 3, but our expert was saying 2. We say it should be a percentage of whatever work was done by replacement contractor, and there's no very obvious reason for making it a percentage of the extra over. If what the judge wanted to do was just give us a very small sum of money, then he should have just done that. But a percentage of the extra over is an arbitrary and, with great respect, irrational calculation. It should either be simply a fixed sum of money, some notional arbitrary sum, or much better, a percentage, whatever that percentage is, of the work that was left to be done. And we have done the calculations, but I don't propose to take the court that those.
Where is the calculation? Don't take it, just to give me a reference.
Oh, the
Oh, don't worry, I can come back. We'll find it in your.
I think it's at D65 and D66 of my learned friend skeleton.
Oh, I'm so grateful. I was looking in the orders because we did get a calculation. I'm very grateful to my learned friend. If just as I close, it is now 11:30. If I D65, I'm whoops. The D65 is
Never
my
mind,
original.
just take time. Yeah.
D65 is my original submission in November 22, and I've done the calculation. We say using 3%, which was the learned judge's percentage, as opposed to the lower figure that Mr. Allen suggested. It should be 3% of the work that was left to be done.
I see.
And that gives one about 200,000 dirham, being 3% of the remaining work, as opposed to, I think it's 6,000 dirham, which was 3% of the extra over.
Thank you.
Because for whatever reason, the extra over was in fact relatively modest. The cost of getting a load of new contractors wasn't hugely different from what we were going to be paying MASC to do the same work. Well, my lord, it's 11:32. We did propose a break for half an hour at 11:30.
Have you finished on this point?
I have finished on all of the employer's grounds of appeal, my lord.
Okay, fantastic. So we take a half an hour break. Now mine is 7:32, 7:33. So past the hour. So we'll meet, say, about 5 minutes past the hour.
Yes,
5
certainly, my
minutes.
lord.
Very well, my lord. Thank you very much.
And 5 minutes, 4:30, 4 past minutes, 4 p.m. Dubai.
Sounds good.
Right? Great.
Right. Okay.
Thank you very much. Everybody.
My lord, just before my
Okay,
learned
fine.
friend responds, can I just
Yes.
clarify? I was asked a question. I'm very embarrassed not to be able to provide a competent answer. I was asked a question about the costs in the Dubai courts. Having taken instructions, I'm instructed that it is conventional and standard in the UAE courts for only nominal legal costs to be awarded in the range 1,000 to 2,000 dirham. So the answer is we were awarded costs, but in a nominal amount only, and our claim is for the actual costs that we incurred in preparing for and contesting the claim.
Okay.
So that is how that claim arises.
Thank you. Thank you very much. Okay, then, Mr. Burrell.
Thank you, my lord. So I'll deal with the ground. Which is that the judge was wrong not to exclude MESC's delay evidence or fail to adjourn the trial because of MESC's failure to disclose programming data. I've got 7 submissions in relation to this. So the first is, and it's a point that my lord Glennie, I think, highlighted earlier, which is what is the error? Now, this is not an error of law. It's not an error of fact. It's an error in the exercise of the judge's discretion. So the law that, so I think that this is admitted by PANTHER, within their skeleton. So we need to look at what the test is required in relation to an exercise of judicial discretion. It's submitted that by the appellant it's at E725. And this is the case of Prescott and Potaminos, which is a recent court judgment from the English Court of Appeal, I think. And paragraph 76 is, so on a challenge to an evaluative decision of the first instance judge, the appeal court does not carry out a balancing task afresh, but must ask whether the decision of the judge was wrong by some reason of identifiable flaw in the judge's treatment of the question to be decided, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermined the cogency of the conclusion. So that is the test. It's not a fresh balancing exercise. It's not, did the judge get this right or wrong? It's not, would we have done this differently? It's whether there was any identifiable flaw in the judge's reasoning, such as a gap in logic or similar. None of Panther's submissions address this test or stand up at exercise of discretion are we applying this test towards. So if we look at Panther's ground itself, it's at D39. And the ground itself says that having been found in breach of a court order, the appellant failed to disclose program material, the court should have imposed a sanction commensurate with the prejudice, namely barring the appellant from relying on the expert evidence or adjourning the trial to allow the respondent's expert to file a new report. So this ground, to clarify, is centered on the failure to disclose in breach of court order and the determination on how to deal with this. It is not related to any allegations regarding MESC's delay expert partiality. It's an exercise of discretion regarding MESC's alleged failure to comply with the court order. So was there any identifiable flaw in the judge's exercise of discretion in not excluding MESC's expert evidence or in not adjourning the trial, having regard to this failure to disclose in breach of a court order? So it is next necessary to review exactly what the judge knew about this programming material and the alleged breaches, and when, and in particular how Panther, the alleged aggrieved party, had requested the court to deal with this. Before I'll do that, I just want to draw the court's attention to a case which is relevant to this point, Meat Corp of Namibia. It's at E259. This case concerned, or it actually concerned an application to exclude evidence in relation to, as a result of alleged partiality of experts rather than any failure to disclose. But the point is a similar one because it deals with when it's appropriate to exclude a party's evidence and how that should be dealt with by the parties. So I'm looking at paragraph 46 in particular, and the judge in this case states, I think it's about halfway down. So about halfway down that paragraph, in those cases, it may not be possible to determine the matter at pre-trial stage. It is obviously desirable to do so, if at all possible, so as to avoid the prospect of a party's important evidence being ruled out at the trial with possible consequential adverse effects on the trial process or even unfairness in the decision making. But it may be possible, so I would not rule out the prospect of having to decide the point at trial. So the judge says it's not impossible to deal with it at trial. That can happen, but if possible, it should really be dealt with before trial because of all the possible consequential adverse effects if it is or has to be dealt with at a later stage, and the unfairness that would result from that. In short, given the significance of a determination to exclude a party's expert evidence, any application on this issue should be dealt with as soon as possible, as it could be very unfair to the other party if that evidence was challenged at a later stage. Panther maintain that the first time it was aware of the failure to disclose was when Mr. Singhal, MESC's delay expert, relied upon certain P6 files within his second report which was filed on the 22nd of August 2021. This was around 4 weeks before the start of the trial. I just want to address a brief point. My learned friend said that these files were unreadable. My understanding is that they were unreadable for the purposes of case lines, not that they were unreadable full stop, because I remember exchanging emails with Mr. Dylan Malone in relation to this point when corrections to the judgment were being drafted. That's my understanding, not that they were unreadable P6 files. If I'm wrong on that, then that might be different, but that was my understanding. In any event, the fact that there were these P6 files was disclosed 4 weeks before. The first time this apparent failure to disclose is referenced by Panther is within its skeleton, opening skeleton filed on the 15th of September, about a week before the trial. And within that skeleton, all it does is say that it reserves its position. It is noted specifically that Panther did not request any order at this stage in respect of the alleged failure to disclose. It did not request exclusion of evidence. It did not request an adjournment. During the trial itself, Panther did not make any applications to exclude Mr. Singh's evidence, contrary to what my learned friend said earlier. During the trial itself, there was no application to disclose. In fact, well, during the days of the trial, as it were, nor did it request an adjournment. In terms of evidence, Mr. Allen did give evidence that he said he was constrained by the lack of this P6 data. Panther did not make any application after that evidence. And otherwise, in terms of evidence, Mr. Singhal was cross-examined by Panther's counsel in relation to Mr. Allen's lack of P6 files. So this is within the third day of the transcript, which I think for the court's reference is at pages H580 to H589. The nature of Panther's cross-examination regarding the P6 files was to try and suggest that Mr. Singhal was partial. So if we go to page H590, and the top paragraph, Mr. Dylan Malone says, your evidence is if you were in the shoes of Mr. Singhal, you would feel that you were being treated fairly. You would not feel that in some way a trick had been played on you. The direction of Mr. Dylan Malone's cross-examination was to try and impugn Mr. Singhal's conduct and partiality because of Mr. Singhal's failure or alleged failure to provide the P6 files, not Mesk's. So he was trying to suggest that Mr. Singhal's evidence was tainted because of that point. So that's a strategic decision that had been taken by Panther in relation to this. The next time this issue really comes up is on the final day of the trial. And again, it's not raised by Panther, it's raised by the judge. We go to H809. And he says there in the middle of that page, one of the things I'm going to want to be explored is whether Mr. Allen's evidence was constrained by the lack of P6 files. Interestingly, if we then go to H812, there's a discussion about the orders for disclosure, and it's apparent that it's at this stage the judge realizes that there was an allegation that their orders hadn't been complied with, and the judge says that they're in this state of affairs to have. Sorry, lad.
You went silent for a minute.
Apologies. Can you hear me now?
Yes.
So the part there, it says it was of course open to Panther to have sought an order barring defence of the claim in absence of the production documentation. So that's a point that the judge raises at that stage. Even at this stage, Panther does not make any application to adjourn or to exclude. The next point at which this comes up is at page A219. And these are Panther's closing submissions. And this is a section entitled Consequences of P6 Programme Controversy. There then follows about 4 pages of submissions by Panther. Almost all of those submissions are directed at the independence of Mr. Singhal. They are not directed at Mesk's failure to disclose. So having regard to the grounds of appeal again, and the discretion which the judge is being accused of having assessed incorrectly. whether the judge should have adjourned or whether the judge should have excluded Mr. Singhal's evidence because of this non-disclosure. So this is my fourth general submission, but it's about adjourning the trial. There was no application to adjourn ever, or an application for any further evidence at any stage before, during, or after the trial by Panther. So what Panther's appealing here is the judge's failure of his own volition to adjourn the trial. In my submission, there's clearly no flaw in a judge's discretion to continue with the trial or to allow Mr. Singhal to give evidence when no application has been made by Panther or by either of the parties for an alleged failure to disclose. It is a party's obligation to make a formal application if it wishes to adjourn, or even an informal one that was hearing if timings allow, which they would have done in this case because the P6 files were disclosed at least 4 weeks before the hearing. If a party considered itself to be so prejudiced by a late disclosure of evidence in breach of court order, it is up to that party to take the necessary procedural action. In this case, Panther decided to tactically reserve its position and then to try and use this to attack Mr. Singhal's independence. There can be no logic in the judge's decision, no lack of logic in the judge's decision to continue with the trial, given there was no application to adjourn, and having regard to the overriding objective, it's necessary to continue with trials, given the cost of doing so, or adjourning if there is no application otherwise. Finally, on this, I just want to posit that, can you imagine the precedent that would be set down if this court found it was illogical for the judge to have not adjourned the case of his own volition for alleged disclosure breach, despite neither party requesting an adjournment? Clearly, that is not an appropriate situation. So my fifth submission, and this appears to be Panther's primary case, which relates to the decision to not exclude Mr. Singhal's evidence. Panther did not apply to exclude Mr. Singhal's evidence before the trial on the basis of this non-disclosure for apparent strategic reasons, so that it could use this and challenge Mr. Singhal's partiality. It only applied to exclude Mr. Singhal's evidence in its closing submissions, and even then, it premised its application on Mr. Singhal's partiality rather than the breach of production order. As such, what we are reviewing is whether there is any identifiable flaw in the judge's reasoning following Panther's closing submissions after all the evidence had concluded to refuse Mr. Singhal's evidence because of MESC's failure to disclose. Now, I've got 6 subpoints in relation to this. The first subpoint is exclusion of expert evidence is a draconian sanction. It deprives a party of its very important evidence. This is even more draconian if this decision is to be taken after the trial and after all evidence has been heard, thereby effectively handing the position on that issue entirely to the other party and the significant financial implications that would flow from that. Accordingly, a decision to exclude expert evidence after a trial and all evidence has been heard must only be made in very rare circumstances. Having regard to that, in my submission, the judge's criticisms of Panther did not lack logic. So my second subpoint is that the judge's criticisms in deciding to not exclude Mr. Singhal's evidence did not lack logic or were not inconsistent. So if we go to B124, I'm looking at paragraph 200. Now, this appears to be the main criticism of Panther here. He says, Panther had the opportunity to raise the unavailability of the missing P6 files when Mr. Allen and Mr. Clark began working on their final delay report, and no urgent protest was raised after copies of the files were made available on the 22nd of August. Instead, a decision was made to continue to rely upon those reports, whilst at the same time continuing to complain about MESC's failure to produce. So the judge is apparently here highlighting what I submitted earlier, which is that Panther made a deliberate decision to not raise this point. And instead, although the judge doesn't letter it out, they'd taken a strategic decision to utilize that to discredit or to attempt to discredit Mr. Singhal. There was nothing further, there was nothing preventing Panther from making an application to exclude. All of the information was there available. It wasn't something that came from trial which enabled them to make the application. In relation to the non-disclosure, that could very easily have been done 4 weeks before the hearing. As such, there is no excuse for Panther having not made that application or not taken any action prior to the trial. It was Panther's strategic decision to not do so, deliberately deciding not to do that and try and impugn all of Mr. Singhal's evidence in the hope that both it on delay and quantum, because they applied for it to be excluded on both of those, was excluded. That the judge took this into account was not illogical. This procedural gamesmanship should not be rewarded by a party then being allowed to or try and get it excluded on the basis of the non-disclosure after all the evidence has been heard. Panther suggests in its skeleton and in my learned friend's submissions today that it's not proper to chastise an innocent party for not taking action. But that is surely incorrect when the failure to take that action impacts the other party, e.g. by allowing its expert evidence to be fully heard and the prejudicial effects of possibly excluding that evidence later on. So put simply, and as I've already stated, it's not illogical for the judge to have taken into account Panther's procedural options and expert evidence, Panther's procedural options when determining whether the very high threshold of excluding a party's expert evidence is met, having regard to the serious unfairness of excluding a party's expert evidence. And finally, in relation to this, in relation to the comments made about Mr. Allen, it's my submission that these comments were for context. The main complaint is about Panther's actions. Furthermore, it's common for parties' experts to request documents off other parties' experts. And indeed, the point is that it goes to how much or to what extent Panther really considered this was essential. But the complaint really is of Panther, and the other points about Mr. Allen are for context in relation to that. My third subpoint is that the judge's decision to exclude Mr. Singhal's evidence did not solely rely upon Panther's procedural actions. It also had regard to the lack of prejudice which Panther had from the non-disclosure, which illustrates that it was not illogical or inconsistent. So this deals with the other point that my learned friend raises, which is that it was such an important issue, this documentation, that the judge should have considered that more or made a different decision because of that. My learned friend went into extensive submissions earlier today, suggesting that it is impossible to do an analysis without P6 files. Now that I am surprised at. Now, Ms. Mort is obviously significantly more experienced than I am in construction cases, but in my previous years working in complex delay claims in the UAE region, almost all of the delay analyses that have been preferred are as planned, as built. In fact, that's often cited at delay seminars as the most reliable form. As planned, as built, contrary to what Mr. Mort alleges, is not only to be used in simple cases. A critical path is still established by an expert programming or an expert who's got significant programming experience. It relies upon a significant amount of data, including data from the programs, but those can also be from PDF programs, not just the P6 programs. And throughout, Panther had all of the PDFs of that programming data. It's just the P6 programs that can be used within Primavera for specific analysis which rely upon P6 programs, which I'm going to come on to. As planned, as built does not rely upon P6 programs. It relies upon other data, and it's dealt with in a different way. In my experience, that is the most common form of analysis that's ended up being preferred in complex delay cases in this region, but also elsewhere. In fact, this can be proven a little bit by looking at the SCL guidelines, which obviously specifically set out as planned, as built as one of the forms of analysis. So if we go to G99, we can see here, these are the different forms of analysis that are summarized within the SCL guidance document. and it's the top four that are usually the most commonly used. But the two that I'm interested in really are time impact analysis and as planned, as built. So in that box, the second down and the fourth down. The analysis that was relied upon by Mr. Singhal was as planned, as built. And you can see within that, it says analysis type in the second column, effect and cause. And in the fourth column, delay impact determined retrospectively. That can be compared with time impact analysis, the second box down, cause and effect, and delay impact is to be assessed prospectively. Now, the analysis which Mr. Allen wished to undertake in these proceedings, had he been provided with the P6 files, was a TIA analysis. If we go to H321, this is my cross-examination of Mr. Allen during the proceedings, and the question and he says yes. So to clarify, and then the next question is to clarify TIA is a prospective method of analysis, and he says yes. So all that Mr. Allen would have done if he had had the P6 files was undertake a TIA analysis. TIA analyses are what should be undertaken during a project as the project is ongoing, because they forecast future delay. They're looking at the data and they're saying, this will cause delay in the future. This is future delay that's going to be caused. After a project is finished, or is forecasting how the P6 files are indicating what will be delayed in the future. After a project is finished and during proceedings, during litigation or proceedings, retrospective analyses are considered to be considerably more reliable. This is well known in the industry, and it's also logical, as you can actually see what has caused the delay, rather than forecasting or predicting what will cause the delay. But you don't need to just take my word for it. The SCL says this. If we go to G97, and I'm in particular looking at the bottom paragraph here, which is 11.4a. And it says here, certain methods start with identification and description of event, a cause, and thereafter seek to establish its effect. These are cause and effect. Others start with identifying the critical delay and effect, and thereafter seek to establish what might have been caused. These are effect and cause. So you have cause and effect and cause. Where the EOT application is assessed after completion of the works or significantly after the employer risk event, then the effect, and just over the page, the effect and cause methods are generally considered to be more forensically reliable because they consider any and all potential causes of delay. The next related point in relation to this is just if you scroll down the same page, it's at G98 and subparagraph E. And this says delay impact is determined in one of two different ways. A prospective delay analysis identifies the likely impact of historical delay data on a completion date. The conclusions of a prospective delay analysis may not match the as-built program, because the contractor's actual performance may well have been influenced by the effects of attempting acceleration, etc. And a retrospective delay analysis identifies the actual impact of the delay events on the identified actual or as-built critical path. Effectively, that paragraph is suggesting that a retrospective delay analysis is likely to be more reliable in assessing delay impact than a prospective. As already stated, a TIA analysis is cause and effect, and it's a prospective in terms of assessing delay impact. In comparison, an as-planned, as-built analysis is effect and cause, and it assesses delay impact retrospectively. It is commonly used, APAB, and it's generally considered to be much more reliable in retrospective and once the completion works are finished. P6 files enable the use of software-driven analysis, but they don't mean that other types of analysis cannot be conducted if you don't have them. The employer had all the data from the PDFs of these software files. As such, it was able to undertake an as-planned, as-built analysis. doesn't mean that it was unable to construct a critical delay path. Before I move off the SCL, if we go to G101, and I'm looking at paragraph D here, and I'm looking at the second line, and it says, as distinct from a time slice analysis, it is less reliant on programming software and usually applied when there is concern over the validity or reasonableness of the baseline program or the contemporaneously updated programs, and or where there are too few contemporaneously updated programs. So contemporaneously updated programs, that's the P6 files, effectively. So what the SCL is saying is when either you don't have the P6 files or not enough P6 files, or there are problems with the P6 files, APAB is the type of analysis that should be preferred. Without the P6 files, Mr. Allen was not prevented from undertaking an APAB analysis. He could have done that, and it's not argued differently. There's no risk, there was no constraint on Mr. Allen conducting an APAB analysis without the P6 files. Furthermore, if we look at the judgment itself, if we go to B124, and I'm looking at paragraph 199, and the judge says here, Mr. Singhal testified that he'd studied the P6 files. He stated that he did this as a preliminary assessment of the information available, which revealed that the files contained mistakes, which caused him to decide to make no further use of them in his first report. He says, finally, PANTHER is not in a position to challenge its evidence, but I think it highly unlikely that its evidence was false or otherwise unreliable. So what the judge has effectively found there is that the P6 files, or he accepts Mr. Singhal's evidence that the P6 files contained mistakes, and therefore an APAB analysis was the right one to have undertaken. If we then just scroll down to paragraph 205, so that's a B126. The judge says, in my view, in these circumstances, Messrs. Allen and Clark ought to have conducted an APAB analysis. Even if they didn't have the files, which, and my learned friend suggested they were prejudiced from not doing so, they could have still done this analysis, but they didn't. And even if they were provided the files, the maximum effect of that would have been, they would have realized that they were unreliable, and then they would have had to conduct this analysis. Either way, we're coming back to this analysis, and the fact that they didn't do it in the first place is their own issue, not through any failure to disclose. Indeed, the judge finds, if we scroll up at paragraph 203, and Mr. Singhal conducted a retrospective APAB analysis in accordance with the SCL protocol. In my judgment, this was clearly the most appropriate course to undertake. None of these findings are appealed by PANTHER. So whilst and finally, in relation to this, in relation to alleged prejudice or lack of prejudice for PANTHER and not having these files, as stated, they were not prohibited from undertaking this analysis. They could have done that, so they weren't properly done. They weren't restricted. But also, it may be alleged that because Mr. Singhal used the P6 files within his second report, that they were prejudiced. But Mr. Singhal's second report was not relied upon by MESC during the proceedings, and the judge didn't make any findings in respect of this. The judge said he preferred Mr. Singhal's evidence as given in his first report, and that's at paragraph 203. So the second report didn't even come into contention. As such, Mr. Singhal's first report was not tainted by these P6 files to the extent that it could be, and as such, there was no prejudice in the event. So my fourth sub-point is, it's clearly not an appropriate sanction to exclude the entirety of Mr. Singhal's evidence, as his first report didn't rely upon any P6 files. Why should that report be excluded when it didn't rely upon any of the files which were not disclosed? Fifth, in respect, now whilst it's not specific to this test, it is helpful context. The reason Mr. Singhal's evidence was preferred was not just related to, or was not heavily related to the fact that Mr. Allen did not have those P6 files. If we look at the judgment at paragraph 204, you can see there, and he says about halfway through, Mr. Clark did not conduct an independent analysis to verify what was the correct critical path, instead considered the pleaded delay events. Now that is possibly related to the P6 files, but he says even without the benefit of the P6 files, this evidence could be seen in some significant respects to be unreliable, as was recognized in the following answers. So the judge has effectively, regardless of whether the P6 files were disclosed or not, the evidence of Mr. Allen was found to have been unreliable in other respects. As such, it's still not the case that these P6 files prejudice Panther. In any event, that's not the test really. The test is whether the evidence should have been excluded because of this lack of P6 files or not. My sixth and final submission in relation to this. So just to clarify, Mr. Singhal's partiality isn't subject to appeal, as already stated, and the judge had found his evidence was reliable. So to the extent that that is relied upon by the respondent, it's not relevant. The sixth submission is, should there be a challenge to evidence, as already stated, this should be done before a trial. Otherwise, the trial has to be reopened with all the costs that this goes to. Had the lack of disclosure been raised before the trial, various options could have been pursued by both parties, or various different possible. I mean, it's possible that Panther could have had a supplemental report, or Mr. Allen could have included this analysis within his presentation, as he did with other aspects of his quantum. Instead, MESC conducted the entire trial proceedings on the understanding that it would be able to rely upon its expert evidence. Panther's requested relief would undermine the finality of proceedings if its application or if its appeal was allowed. It would indicate that parties can wait until after trial proceedings have been concluded, possibly attempting various strategies in between, until it applies to exclude evidence based on non-compliance with orders several months before the trial. It would disincentivize parties from making timeous applications regarding the alleged disclosure, just so they could be strategically deployed after proceedings have been concluded. So it was accordingly logical for the judge to have taken consideration of the fact that these procedural options had not been explored. What Panther is effectively now attempting to do is, if MESC is successful on its appeal, is to have another bite of the cherry. Its expert evidence was not preferred for various substantive reasons unrelated to the lack of P6 files. And it's an attempt to get a supplemental report in through the lip backdoor and relitigate delay issues, which were unsuccessful the first time around. It is different to the factual findings that MESC rely upon as well in terms of what would be needed. If Panther was successful on this, there would have to be an entire rehearing on delay evidence. Because even if Mr. Singhal's evidence was excluded, Mr. Allen's evidence wasn't accepted. So there would have to be a retrial on all of the delay evidence. As such, and this can be compared with the factual findings that MESC contends for in its appeal, which are limited to documentary evidence in relation to notices, this is oral evidence that would have to be reheard. Those are my submissions on ground one, unless the court has any questions for me. Thank you. So ground two, this concerns Panther's appeal in relation to general damages for delay. And I have 6 submissions in relation to this. My first submission is that there would effectively be no change, even if Panther was successful on this ground. This is because if we go to the judgment at B128, and we're looking at paragraph 208 and 209, and the judge says he accepts Mr. Singhal's evidence of the delays and says 306 to Panther. And at 209, he says it follows that even if Panther's claims for loss of opportunity or higher return by reason of MESC's culpable delay in completing the project or loss resulting from delay were permitted under the terms of the contract, these claims would fail on the ground that Panther had failed to establish that the delays it pleaded were the result of breaches committed by MESC. Now, my understanding that that provision, that paragraph itself is not appealed, because that relates to the findings in relation to the causality of delay. As such, having regard to that finding, and it's not related to the appeal ground because it's separate to the interpretation of clause 8.7, which is what Panther really relies upon. This ground goes nowhere. The judge has found here that regardless of the correct interpretation of 8.7 or not, these claims failed because of these findings on delay. As stated earlier, my learned friend went to great pains yesterday to suggest that MESC didn't appeal factual findings. As I've already stated, we suggest that is connected to this ground. But this factual finding is not connected to an interpretation of clause 8.7. As such, my submission, this finding in itself bars relief for ground 2 that's sought by Panther. So just related to, I think one moment.
Sorry, it's my fault. I'm not sure I follow that submission.
Yes, Lord.
The judge, sorry, the claim in ground 2 was for loss of rent as damages for delay up to the termination and then up to completion. Is that right?
Well, there's a point I'm about to come on to in a moment, my lord, because within ground 2 itself.
Yeah.
So this is at D39. And you can see ground 2, it says in error, the court refused the respondent's claim for general damages for delay in circumstances where the amended clause 8.7 allows for that. So and then the skeleton which was attached to that directed its submissions as to the judge's interpretation of clause 8.7. It's not clear from that ground nor Panther's skeleton that actually damages post-termination, which were allegedly related to delay, are the subject of an appeal. And they appear to relate solely to the judge's interpretation of clause 8.7 and how that's to be applied, as opposed to any failure to award damages for post-termination, because the judge's interpretation said post-termination damages could be awarded if they were related to delay. But my understanding is that point isn't lettered out really within their ground of appeal, nor within their skeleton.
What does the judge mean when he says Panther's failed to establish the delays it pleads were the result of breaches by MESC? I thought the judge had already found that there was a valid termination by Panther on grounds of MESC's delay and or breach.
The judge had found that there was a valid termination by reason of abandonment in particular.
Well, why doesn't the delay then result from breaches by MESC? I don't understand what the judge is saying.
In my submission, my lord, this is a question of causality. Is the damage being caused by MESC's delay, or is it being caused by MESC's abandonment, i.e. the termination? And in my submission, the ground 2 of the respondent's ground is related to delay. It's not predicated in terms of the termination or the abandonment. And in the circumstances, the judge is finding that that because Panther was responsible for the vast majority of the delay, it's not entitled to its loss of opportunity or rent for that, or for the delay of MESC.
I see. This is because it's delay beyond the liquidated damages delay.
Indeed, yes. The judge says that liquidated damages are to cover delay in effect.
And when you get beyond liquidated damages, the judge is saying then, despite the fact that MESC hasn't triggered clause 20.1 and so on. Nonetheless, Panther has to prove breach by MESC, or breach entitling it to damages for delay beyond the liquidated damages period. Is that
Yes,
right?
and that it was caused by, in particular, MESC's delay.
Yeah. Okay.
And because of its findings that the delay was not MESC's was not MESC's fault, regardless of the EOT findings. So regardless of the EOT findings, because it was ascribed to Panther, it's not been caused by that.
Yeah. Okay.
So related to that point, actually, I think my learned friend suggested within his skeleton that what we're concerned with here is a failure to complete by the completion date, and as such, the EOT is relevant, or the fact that MESC doesn't have an EOT is relevant to that consideration. It's not just whose fault the delay was. In my submission, that's incorrect. Whilst the EOT is relevant to the application of liquidated damages, it's not to general damages, where you revert to usual causation principles. So the period of time is to be calculated in general damages for the delay by which a contractor caused the additional time because of its breach of contract, and that's to be calculated and assessed.
Yeah.
There is a relevant point. I'm going to come on to this in relation to ground 3 in a moment, but even if the court's not with me on that, Article 15 is relevant to this. Article 15 of the DIFC Law of Damages and Remedies is relevant to this point, but I'll come on to that in ground 3, because it provides for how damages are to be reduced when effectively there's a contribution towards that loss. So even if the court is not with me, that we're looking here at causes of delay rather than EOT. In any event, it's immaterial.
Yeah.
Now, my third submission is in relation to application of triple point. It's a recent English Supreme Court case, which came out shortly before the trial, which both parties relied upon. And if we go to B77, paragraph 94, we can see here that what the judge says is Panther goes on to submit that it's entitled to recover general damages on its caption loss of opportunity claim on the basis that the losses in question is suffered post-termination and not pre-termination. But it's not entirely clear what's being set out here, because during the proceedings, Panther did, within its skeleton, appeared to concede that LDs were payable up to termination and then its general damages thereafter. For the benefit of the court, that's at A103. But it's not entirely clear what a Panther's appeal relates to, because if we accept Panther's position that it did lose an opportunity to sell the units earlier, or lost the opportunity to rent these apartments, this loss would have been sustained during the period of during the period before termination, because that's when the delay occurred, or that's when MESC's delay, or the causes of delay occurred. And so that's when that loss would have arisen, not after. As such, the loss arises before termination, and therefore it's caught by the liquidated damages, as appeared to be conceded by, as Panther appeared to concede. If the loss occurs pre-termination, then that's limited. That's limited by triple point. So having regard to the judge's sort of summarization of Panther's position there, it's not clear where we'd get to, even if this appeal was successful.
I didn't understand, I didn't understand the argument to be. I didn't understand there to be a concession that they couldn't get damages before termination.
Well, I think so. I'll go to this because it's relevant. It's at A103. It's Panther's initial skeleton, although I do concede that Panther did resign from this position to some extent within their closing submissions.
A103.
A103. And I'm looking at paragraph 50, which says it follows that liquidated damages are payable to the date of termination and general damages are payable thereafter. Now, I appreciate that Panther resolved to some extent from this, but within the judgment, and I don't think this point is specifically appealed, the judge says that appears to have been Panther's position, that it accepts it's entitled to general damages, but only on the basis that the loss is suffered post-termination, not pre-termination.
Can you help me? Can you help me on one point? Sorry, I haven't got it in my mind. I ought to. The liquidated damages for delay went up to a maximum of 10% of the contract price.
Correct, yes.
Was that exhausted well before termination?
It would have been subject to the court's determination on the contractor's appeals, but yes.
Yeah. So why wouldn't general damage, because of the amendment to clause 8.7, I think it is, or 8 point whatever, why wouldn't general damages click in before termination, as soon as liquidated damages have finished?
So because the parties had specifically considered or agreed for liquidated damages provision, so this relates to an analysis or a construction of the contract. So if we go to the analysis of it, it was C157.
C157.
Yeah. So this is the added paragraph.
Oh, this is, yeah, okay.
And it says here, and are strictly without prejudice to the employer's other entitlements. So there's reference to the employer's other entitlements and shall in no way preclude or restrict the employer's ability to bring a general damages claim. So there's a reference to other entitlements and the ability to bring the ability of an employer to bring a general damages claim, having regard to those other entitlements under the contract. What my submission was during the proceedings and is today is what this was intended to be was a reference that if the contract was terminated, the employer was thereafter entitled to pursue general damages.
All right.
And that's on textual analysis of this provision, but also having regard to clause 15.2H, which is, if we scroll down to and subparagraph H, which says if the maximum amount of delay damages is exhausted, termination is permitted. So it considers that you can terminate.
You went silent when you were saying what paragraph it was. Something
Subparagraph H
of
paragraph 15.2.
Oh, 15.
On page C166, I think. So that allows a party to terminate if the maximum amount of delay damages is reached. And so my submission, that is the other entitlement that is being referenced in part in clause 8.7. And it's when a party is terminating that it can then claim general damages thereafter. Further on review of clause 8.7, sorry, going back, it's page C157. And looking again at this subparagraph, what I would note is the second line. It says here, in addition to the delay damages, the contractor shall compensate the employer for any additional fees that the employer is required to pay to the engineer or other third parties. So it's accepting out specifically engineers' fees from delay damages. If the intention of this clause was to allow Panther to pursue general damages, regardless of the delay damages or regardless and on top of, there would have been no need to accept this point out, because that, as I'll come on to in ground 3, is a general damage. That is a general damage. The engineers' fees are to be assessed as they are general damages. They're not a specific daily rate. So that's accepting out a specific item of general damages in addition to delay damages. The fact that that's been done here indicates that the parties had intended, save for that exception, only delay damages to apply up until termination. So on a textual analysis, that suggests that the parties did not intend general damages to apply beforehand. And so that's on a textual analysis. On a contextual analysis, so having regard to the purpose or the commercial purpose of liquidated damages clauses, if we go to A292, and these are the contractor's reply closing submissions, and I'm looking in particular at the bottom, paragraph 155 and 156. In 155, triple point is cited, and there's various extracts. There's two extracts there, and in particular the bold extracts are relied upon by MES, because what they do is that what's set out here is the benefits effectively of a liquidated damages provision. They say why parties agree to these provisions, which is for the benefits of certainty, simplicity, and efficiency in quantifying these damages. Otherwise, there's considerable uncertainty as to what would be recoverable if delay occurs, and it would deprive parties of the advantage of knowing in advance their potential financial exposure. In my submission, clause 8.7 should be interpreted having regard to the commercial purpose of liquidated damages and the position of the parties in this. If clause 8.7 was to be interpreted, and this is set out at 156 of this submission, if clause 8.67 were to be interpreted as PANTHER alleges, which is to allow general damages in addition to LDs if delay occurred, this would undermine the purpose of LDs, which is to provide a predictable and certain remedy. Instead, it would add considerable uncertainty because there'd be LDs and then there may or may not be additional general damages on top of that. It would deprive MES of knowing its financial exposure in advance of exactly what it would be exposed to for its delay. It's definitely got the liquidated damages, save for the appellant's arguments in this case, or the appellant's grounds, but it wouldn't have any knowledge of what the general damages would be for, or how much general damages would be. And so it seems kind of antithetical that the parties would agree a liquidated damages provision, but then also agree a general damages provision to be applied for that same period of delay. It just doesn't really make much sense as to why that would be agreed. So in my submission, 8.7 should be interpreted as it's LDs to be provided for the delay which occurs pre-termination, and then it's the reference to or the exclusion of, or sorry, the reference to general damages within that clause is to general damages after termination, which was the judge's interpretation. My third submission in relation to this is just briefly Article 54 of the IFC contract law, which is the contra preferentorum point. These are clearly PANTHER supplied terms, and so they should be construed in favour of MESC. And fourth, it is a very unusual position if a party is able to choose general or liquidated damages for delay. I've not really seen any authority on it before, and no authority has been provided by PANTHER that would suggest that is permitted. And in my submission, this clause should be construed accordingly, that's not what the parties would have intended for that exact same period of delay. Otherwise, I made submissions in relation to penalties within my supplemental skeleton. I think my learned friends clarified now that PANTHER are not seeking to recover both LDs and loss of opportunity for the same period. That was not clear before these proceedings or these appeal proceedings, because in the initial proceedings, Mr. Allen had stripped out certain costs of alleged loss before termination, but had not stripped out the loss of opportunity or rent. As such, at the time, these were both still pursued during the initial proceedings. But if they are to be stripped out, I accept the LDs aren't penal in nature. My final submission is in relation to liquidated damages being a cap on general damages. This is already set out within my skeleton, and I understand my learned friend's got his own points in relation to that. But I would submit that the parties had intended that LDs to be a cap in any event on any general damages, and there's some law supporting that. Cited at A168 of my submissions. So the third ground is ground 3, which is, sorry, before I move off this, just in relation to the post termination liquidated damages that are being pursued by Panther. So if the court is with the contractor that the clause is only intended to apply to general damages post termination, not pre termination. In my submission, as I stated earlier, in any event, I suggest that the appeal ground was centred on the interpretation of clause 8.7 and the judge's decision on that, and as such, the judge's decision in relation to the causality of delay is not challenged, and/or any decision or failure to award general damages.
You've gone silent.
Sorry, am I back in now? Am I back in?
Yeah, I missed the last 10 seconds.
Okay, well, sorry. So the last 10 seconds was, I do apologise, I'm not sure what's wrong with my microphone at the moment. I know that was an issue yesterday. It's my submission is if I'm wrong on that in any event, it is of course going to be necessary for there to be a rehearing in relation to the issue of general damages post termination. My learned friend suggests that the court merely adopts Mr. Paul's figures. Now that I think my learned friend appears to concede that seems an unlikely prospect. There was oral evidence by both parties during the proceedings as to this issue, which obviously was not the same. So Mr. Paul's position was challenged. On that issue because it's not heard that oral evidence. It can't make a decision on that issue. It's not a matter of looking at notices and deciding whether they're valid or not. That's very, very different. That's documentary. This is an expert's evidence which was given orally. As such, it would need to be remitted if the court did find that this ground needed to be or was accepted. Also related to this, I think my learned friend had given a figure for 3.4 million or thereabouts. I'm unsure how that's calculated, but I suspect it's for the entirety of the time from November until completion. But that's not what would have been caused, or that's not what that period or that entire period or any delay over that period is not what would have been caused by the contractor, because there was still something like 18% of the work left to be done. So there'd have to be an assessment of how much extra over delay there was over that time, possibly mitigation and otherwise, and whether that delay was actually caused by MESC. But in any event, my main submission on that is that this appeal ground doesn't appear to be related to the fact that these losses, or that the judge failed to give an award for losses arising out of the termination. It's for losses arising out of the delay, and the judge has already said that because MESC was not responsible for the delay, as such, this appeal ground can be dismissed on that basis. So moving on to ground 3. Panther alleges that the judge was wrong for rejecting its claim for pre-termination professional fees. So it says C157, I think, if we go back to that point. And it's that second sentence, and said that these additional fees have not been calculated. My main submission in relation to this is that these engineers' fees are general damages. Panther appears to concede that they are general damages, and as such, that must be correct, because there's no specific daily amount for engineers' fees. So they are to just be assessed in accordance with usual causation principles. Who caused the delay? So the starting point is looking at how many days of delay MESC actually caused. The EOT mechanism is related to LDs and the completion date. It's not related to general damages. As such, and given the findings in relation to causality for delay by the judge in this case, I submit that there be a limited, if any, award in relation to engineers' fees in relation to this item. Even if I'm wrong even if I'm wrong in relation to the relevance of EOT on assessment of general damages, which I obviously resist, in my submission, Article 15 of the DIFC Law of Remedies which is E773. This is something I referred to yesterday in relation to our new ground. It's Article 18. Where the loss is due in part to an act or omission of the aggrieved party or to another event as to which that party bears the risk, the amount of damages shall be reduced to the extent that these factors have contributed to that loss. In my submission, that is opposite to an assessment in relation to the general damages from this provision, from this case, as clearly MESC is responsible or bore the risk of 306 of those days. In relation to, those are my submissions on ground 3. In relation to ground 4, this is the Panther's claim for the legal costs arising out of MESC's site invasion. My understanding is Panther primarily just alleges that the judge's reason was not legitimate. In response, in my supplementary skeleton, I set out that this was an appeal against a judicial discretion. Panther suggested that's wrong, but it's not clear why the judge says that's wrong. So why Panther say that's wrong, or why the Panther say the judge was wrong. It's not a factual finding that's been challenged, nor a decision in law as such. It's an exercise of discretion, as I understand it. In my submission, the judge was not wrong in his discretion, save for one aspect, which I'll come on to in a moment. The judge was well entitled to decide that the Panther ran the risk of the Dubai court proceedings and that it would not recover sums in those. The point that I do raise issue with in relation to the judge is actually that he gave any sum at all. So that any costs which relate to the Dubai court proceedings must be only a matter for the Dubai onshore court's jurisdiction and cannot be claimed in these proceedings, whether predicated on a breach of contract or not. The Dubai court had jurisdiction to award those costs. For whatever reason, it did not do so. For the DIFC court to now award sums to Panther for these costs would conflict with the Dubai court's decision and interfere with the jurisdiction of that court. This court should not set a precedent which allows parties to claim costs which were not allowed in other proceedings, as otherwise there could be substantial ramifications. As such, sorry, my lord.
I think this court has done that actually quite recently in a case involving fees incurred in Malta.
I'm not aware of that. I'm not aware of that authority, my lord.
For all those damages in the DIFC court, because the Maltese courts had a policy of not awarding costs, and therefore the costs incurred in trying to deal with a particular situation in Malta were recoverable as damages in the DIFC court.
Oh, I'm not aware of that authority, my lord. That rather does spike a little bit of that point, if that is indeed the case. But well noted. In any event, I'd submit the judge was not wrong in his discretion to say that the Panther ran the risk of going before the Dubai court proceedings and recovering sums in that. And there's no lack of logic in through some of the documentation relevant to this, because I think my learned friend suggested that perhaps in his skeleton, and maybe that I've read that wrongly, but I think Panther suggested that there's somehow 200,000 in relation to this claim. I suggest that that's not an accurate assessment of the legal costs that were related to this point. This is all set out within the exhibit at G145. So all of these invoices that were relied upon for these fees are within this exhibit, and quite a lot of them predate the site invasion. So this first one on G145 does. The one on G149 is in July 19. The one at G153 is in October 19. So all of that predates it. G157 it does not predate it. This does cover this period. But you can see within this that there's only a few items that actually relate to the Dubai court proceedings rather than DIFC. There's only a few items. If we go to the next page, you can see on the 14th of November, for example, Jebel Ali police station. And and there's various others which if the court deems it necessary can be gone through. But actually, it's only really on this document, so this invoice dated the 30th of November, that there's some items which relate to this advice that the judge gave an award in relation to. I think in actual fact they'd likely add up to less than the 50,000 the judge awarded, but it's probably a similar sum to that. The items which Panther appear to be appealing is not the advice, but rather the proceedings themselves. And it's my understanding there's only actually 2 invoices that relate to this. One is one G164, and that's for 47,000 dirhams. And the other is G167, which is for 24,000. So that's a quantum point. Unless the court has any other queries in relation to that, I'll move on to ground 5. So this ground concerns the judge's decision to award a sum for the fact that there was not to be any warranty for some of the work unfinished when MESC was terminated. The judge awarded 3% on any additional completion costs. Panther suggests it should be 3% of the total value of work completed post-termination. If I could go to my supplemental skeleton, which is D96, and down to paragraph 90, this is the submissions that the contractor relies upon in relation to this. And the main one is, or one of the primary ones, is that there's no legal or contractual basis set out for why this claim should be awarded. It appeared to be a point plucked out of midair initially by Mr. Allen. Wasn't pleaded within, or this wasn't pleaded as a specific item within Panther's case, and no contractual basis was set out for it within its closing submissions, or legal basis either. As such, it's not clear on what basis this sum could or should have been awarded. It's to cover alleged costs associated with a lack of guarantees, but we're not entirely sure whether these new contractors did offer guarantees or not. I'm not sure. I can't recall if that was a matter in evidence or not.
Well, on the assumption they didn't, for the moment, assume that. Can you see any legal basis for any legal objection to the claim?
Well, my submission, because there's no legal or contractual basis for how it should have been awarded.
The legal basis put forward would simply be that you were in breach. They terminated. They had to get new contractors, and the part of the costs of that damage suffered is that they didn't have a guarantee on the work done after that date.
Well, in that case, my lord, if that is to be the case, or if that is accepted to be the position, in my submission, the judgment on this issue didn't lack any logic and was not consistent. This is a matter of an exercise of discretion by the first instance judge. He came to that assessment after having heard the evidence, and indeed actually having this point was specifically raised by Panther during the corrections to the judgment point issue. I think it's at 1 moment.
Why do you say it's a matter of discretion? Damages are a matter of law, fact finding.
Well, it's the judge's discretion in terms of how he came to that assessment of what to award. So we're not suggesting that the judge was wrong to have awarded 3% on the additional completion costs. It's the discretion as to whether it's awarded on that or whether to award it on some other sum.
That's a matter of law. But you say it's discretion.
Well, we say it's discretion because it's a choice between either the judge chose to award it on additional completion costs or on the total value of the project, because the judge was, it's an exercise of discretion in terms of his assessment of how much to award for this item. My learned friend suggested that a token amount could have been awarded in the alternative. So it's an exercise of discretion as to what sum should be awarded in those circumstances, as opposed to what is required to be awarded according to the requirement of law. because it's an assessment of how those damages were to be considered, or what quantum of those damages should be applied. And so the issue was raised, as stated, within emails to the judge during the process of finalising the judgment. But he maintained his decision in relation to this, so he was aware of this point. In my submission, the award on any extra overcosts could have been considerable. It might have been an extra 3% on an extra 10 million. So it could have been unchanged. It could have been a significant amount. The fact that it's not a significant amount does not mean that the judge was wrong in relation to that. He came to an assessment of what should be awarded for this amount, for these lack of guarantees. He made an assessment based on what is the risk of that being complained about. What is the risk of there being a claim which there isn't a protection for those guarantees on, possibly considering whether there may be guarantees or not. And he made an assessment saying, well, I think it should be 3% of the additional completion costs, not 3% of the total work completed, because perhaps he assessed it to be a small risk or what have you. And so in my submission, the judge wasn't wrong to have come to his decision in relation to that. Those are my submissions, unless the court has anything further from me.
I've got nothing. Thank you very much.
Thank you very much, my lords, and thank you, my learned friend.
Mr. Mort.
Thank you, my lord. We're a little bit behind time, but I anticipate being relatively brief. My lords will be glad to hear. So if I just take the grounds very quickly in turn, the first one is ground one, and the decision not to exclude the expert evidence. And my learned friend accused my client of, in his term, gamesmanship. And the implication of my learned friend's case was that we had deliberately waited until after the evidence before seeking to exclude the expert evidence. Now, I wasn't involved in the trial, so I don't take that allegation personally, nor do I in fact know what my predecessor was doing. But nonetheless, that's a wholly inappropriate and unjustified accusation made against the employer. The short point is that the contractor deliberately withheld key material in defiance of two court orders, namely the P6 native programs. So if there was some tactical game going on, it was on the contractor's side, because it is to be inferred, knew full well that material would, if we were to have it, would be very unhelpful to the contractor. There's no other explanation of why they didn't comply with the two court orders is given. So it was the contractor who chose not to comply with the orders, and thereby ran the risk that there would be, as it were, a mistrial, that the experts would go into evidence, that one expert would have an advantage over the other, and that the court might, in those circumstances, do what we say it should have done and exclude the contractor's evidence. And in terms of my clients, Altamina's approach, the lawyers, my instructing sisters dealing with the trial, as I said in my submission earlier today, we point out that when going into a final account dispute, there's an enormous number of issues to deal with in a very short period of time. It is inevitable that that a litigant will concentrate on trial preparation and not on point scoring or necessarily enforcing court orders. My predecessor ultimately reserved the employer's position generally, not, I suggest, as some sort of tactical game in order to then make the submissions that they did in due course, but for the same reason that one inevitably reserves one's position in such a case, because it wasn't necessarily immediately apparent what was to be done or how it should best be approached in circumstances where my team was trying to get ready for the trial. So that's that. Sorry, my lord.
You make the fair point that in preparation for a trial, there's lots of things being done and everyone gets very busy and so on. But this was by far the biggest item. Yes. It was a delay claim worth in the region of 40 plus or minus million dirhams. Is that right?
It's 4 million, my lord. The contract sum is 40 million, and the liquidated damages is 10% of that, and then there's a prolongation claim as well, of course.
Okay, but there's the 4 million odd delay damages, and then the argument about prolongation costs and so on. So it was potentially by far the biggest item in dispute.
I'm sure that's right, my lord. Yes.
I don't quite understand your point that it just gets left to be, everyone's just scrabbling around trying to get ready and don't have time to think of these things.
Well, obviously, my client was thinking about their delay case and their preparation of cross-examination and so on. I think what I meant, I wasn't seeking to diminish the significance of the delay case or the significance of this material. I was simply suggesting that any advocate going into a trial is concentrating on their cross-examination, their submissions, the legal arguments, the immense number of factual issues, and so on, rather than looking at the procedural position. I anticipate that a trial judge is concerned with the procedural position when the trial starts, because they are supervising that aspect of the case. But an individual advocate doing a relatively heavy construction dispute presented with many lever arch files of valuation evidence and program minutes and all the rest of it, that preparing some very aggressive application just isn't something that's going to be at the top of the list. And for what it's worth, in my experience, when one is dealt with some very significant application to amend or application to exclude evidence, I mean, it's a huge distraction from the case. So far as my own experience is relevant, I have done a case in 2020 at the beginning of the pandemic. I did a case where we were seeking to exclude evidence as being expert evidence when there was no permission. But it's a huge amount of a huge amount of work that everybody's then got to do. And I'm just asking the court to have some sympathy when I get both the learned judge and my learned friend seek to put criticism on my side, and as my learned friend uses the word gamesmanship, simply because we didn't do more to exclude this. And I do strongly urge the court to reject the suggestion that this was some sort of deliberate tactical maneuver. That's really what I'm concerned with. Whether those instructing me could and should have done more at that stage, given its importance, well, I don't want to comment on that. I wasn't in the situation, but one can understand why they didn't. But what's important is this wasn't some sort of there's no evidence this was some sort of deliberate tactic. So the converse point I make is that it was actually the contractor who was playing a tactical game of running the risk of not complying with 2 court orders and hoping that nothing very bad would happen, because the judge would be tempted to just let it in and not do anything too serious. And that was their game or strategy, case strategy. And we say that is gamesmanship. My lord, in terms of my own friend made some helpful submissions about the different forms of program analysis and what we could and couldn't do. The Mr. Allen's evidence, which cannot be, I suggest, overruled, is that he didn't have the program data, the P6 data, and was unable to prepare a critical path analysis on that basis. And I invite the court to proceed on that basis, which is recorded in the judgment. My lord, my learned friend took the court to the SCL protocol, and if we can just bring that up, I think it was G101. Sorry, so my learned friend took the court firstly to G99, where the SCL protocol sets out a comparison of the different forms of delay analysis. And he drew attention to the first 4, and in particular 1 and 4. And of the first 4, all but the 4th one are logic link based. And I should make clear, my learned friend said that his experience was that it was normal or common to have an as-planned versus as-built Windows analysis. will of course some form of comparison between the planned programme and the as-built is inevitable. It is commonplace that there is an argument about the P6 files. That is an issue that arises in a large number of cases for the same reason every time, because the contractor doesn't want the employer to see how they plan to do the work, because it will inevitably undermine the contractor's case. Now, of the first three, all of them have a logic-linked baseline programme. That's such a rudimentary requirement. That's not some sort of unusual or particularly sophisticated type of project. It's every project of this sort of size and bigger obviously needs a baseline program where the numerous different activities are linked together so that one can see what the actual impact will be. And uniquely, the so-called as-plan versus as-built just refers to a baseline program and then as-built data. In other words, records of when individual activities were finished, used to compile an as-built program. Now, my learned friend took the report to page G101, where there's some commentary on each of these different methods. And at G101, we have the comment on D, which is the as-plan versus as-built. And the commentary from the SL says, as distinct from a time slice analysis, it is less reliant on programming software and usually applied when there is concern over the validity or reasonableness of the baseline program and or contemporaneously updated programs, and or where there are too few contemporaneously updated programs. And then it goes on to say that the exercise doesn't rely on programming software. So the point is that this is an absolute, this is the approach of last resort. One shouldn't be trying to work out using records of meetings how delay events impacted a complex project, because of course there's endless opportunity for the contractor to present the material in a way that suits them and to change the logic and so on. And what's curious in this case is the contractor was using Primavera, was using a logic-linked program, but didn't provide it to the other side. Now, the contractor's expert said, well, he didn't find the P6 material useful because it was unreliable. But that's simply just another red flag. In other words, the contractor has departed from their planning intention in order to make their claims. And so we say, well, that's all supportive of our concern. Now, my learned friend said, well, the question raised in our ground one is, well, what error did we say that the court made so as to justify setting aside the order, which was the sanction imposed by the court? And we say, well, there were two errors that are to be considered. The first one, we've mentioned both of them in our written submissions. The first one is that the sanction applied didn't meet the justice of the case. In other words, the particular problem that arisen was that the court was going to have to assess expert delay evidence or causation of delay in circumstances where only one side had the material necessary to determine that issue as a result of two breaches of the court order. So we say, as a matter of principle, that the court should have been asking, well, what sanction would be appropriate given the nature of the breach and its consequences. Secondly, the second error in principle we say is that the court placed emphasis on the experts and or employers' response. And I understood my Lord Glennie's observation that it was suggested that the court was observing that it can't have been that important, given that rather than that the court was seeking to blame the employer. And we say, well, in both in the transcript as referred to by my learned friend and in the judgment, the emphasis of the court is on my client's failure to raise issues, and we say, for the reasons discussed earlier, that's not fair or appropriate. So there was no, to conclude, there was no strategic element to this. I invite the court to find that the employer was put in an extremely difficult situation and simply responded to it as best they could. but the result was the inevitable one, which is that the contractor's delay analysis was repeatedly preferred. My Lord, in terms of ground 2, so this is the claim for damages for loss of rent or loss of capital sales value from the flats as a result of the delay. And my learned friend suggested that it wasn't clear what we were claiming. I thought it was entirely clear, both from the judgment and our appeal. So if I take the court to D71, this is our draft order that we sought when we applied for permission to appeal, or in our respondent's notice. And at paragraph 2, we say the sums awarded to the respondent as a result of its termination for cause of the appellant's contract and or delays, the responsibility of the appellant be adjusted so as to include, and then we mention the loss of rent and indeed the 70 million loss of sales. The loss of rent of 9.1 million dirham, well, the learned judge explained where that figure came from, and I've taken the court to the underlying calculation, both the 17 million and the 9.1. So it's dealt with in the judgment at B78, and we've already looked at this page. So B78, paragraph 97, the judge refers to the construction of 8.7, and then he alludes to the various figures in Mr. Paul's evidence, and he explains how the 9.1 million is calculated. He is recording what Mr. Paul's evidence is rather than making findings, I accept. But he refers to the 5.6 million being the 12 months from November 18 to November 19, and then there's a balancing figure. It's not 4.5, it's in fact 3.4, but the balancing figure is up until May 2020, and that gives you revenue of 9.1 million, and the capital figure of 17 is for the same period. In other words, the 9.1 million, as referred to in our draft order and in our skeleton, corresponds with loss of rent both prior to termination, which is the 4.5 figure, and from termination to May 2020. And we say, as I indicated earlier, obviously we should be entitled to loss of rent from termination to May 2020, and the court has figures to do that, although I accept that if the court doesn't considers that there needs to be an inquiry, then there would need to be a further fact-finding issue in order to decide whether Mr. Paul's valuations were correct. But in terms of the principle of it, we've made our case entirely clear that we should recover loss of rent to termination and then thereafter. Now, in terms of the causation of that, we're just pausing there. The contractor abandoned site in November 2019, and we were then at that stage obliged to engage new contractors to finish the job, which took us a further 6 months. There's no criticism of us, or rather, sorry, the court rejected criticism of us of taking too long to finish the work. But that delay and the delay-related losses is clearly not covered by delay damages in the contract. The contract was at an end by then, and clearly is covered by our general entitlement to recover for the losses arising from the termination. So that's the, if one deals with it in terms of loss of rent, that would be the 3.4 million, or a higher figure to be determined if it were dealt with in terms of loss of the capital opportunity. In terms of the period prior to termination, we say, as I've already outlined, that it's simply a question of looking at the breach and then determining the losses flowing from that breach. And the breach in this case is failure on the part of the contractor to complete by the agreed date. And the losses are the losses that flow from that breach. Now, during my learned friend's responsive submissions just now, he used the phrase causality of delay. He said that one needed to look at the causality of delay and to look at, and he also referred to usual causation principles. But the usual causation principles are that if a party is in breach of an obligation, then the innocent party is entitled to be compensated for the losses flowing from that breach. There is no scope in that issue for an inquiry into the underlying reasons or causes of the breach. That is irrelevant. In fairness, I made that point earlier, so I'm repeating myself, but I'm responding to my learned friend's suggestion that one needs to look at the causality of delay. There's nothing to do with it. If a party takes on a commitment and fails to comply with it, the reasons for that failure have nothing to do with the recovery of compensation. All one is concerned with is, well, what losses flowed from that breach? Of course, there is a big question considered yesterday as to whether, to what extent the contractor was in breach, having regard to my learned friend's appeals. But if, and to the extent that the contractor did fail to complete within time, and it obviously did even on the contractor's case, because it doesn't have a 100% extension of time claim, even on their case. But to the extent they didn't complete on time, we're entitled to be compensated for that. My learned friend referred to the triple point case as indicated. The triple point is unhelpful. Every case obviously turns on the terms of the contract, and as indicated, it's unusual that a contract would provide for general damages. No such provision is considered in triple point, which therefore is of no assistance whatsoever. My learned friend also sought to put weight on the reference to engineering fees. If I can just bring the clause out one final time. So if we look at the amendment to 8.7, which we have at C157, so as I understood my learned friend's submission, he put weight on the reference in amended clause 8.7 to engineers' fees. And I think the gist of the risk of doing him disservice, the gist of his submission was there is a reference to engineers' fees, and therefore there is not a general entitlement to general damages. Obviously, I don't agree with my learned friend, so I'm no doubt not doing justice to his eloquent submissions. But what amended 8.7 provides for is that three things: that the employer will get delay damages, or as we would call them, liquidated damages; that the employer will get general damages, and that's clear from the words shall in no way preclude or restrict the employer's ability to bring a general damages claim. And in addition to those things, the employer will get fees to pay to the engineer. And so that's what the clause says. My learned friend's argument is, well, why stipulate engineers' fees if there's a general right to general damages? Why bother with that? That tends to suggest some different meaning. He doesn't, as I understand it, put forward what that meaning would be. Whereas we would suggest that ordinary conventions of construction are, well, the first thing is to try and give effect to all of the words. If the parties have included these words, then effect should be given to all of them. The so-called argument from redundancy is to start striking out words as being unnecessary, or to avoid an interpretation as being redundant or superfluous. Is much criticised as an approach to construction. But obviously the correct approach is, where possible, is to give meaning to all of the provisions, even if there is some element of overlap or redundancy. But what we say is the clause clearly means that the employer will be entitled to these three different types of loss. The circumstances in which it claims those losses will be slightly different. Where the contractor fails to complete by the completion date, the employer becomes entitled to delay damages calculated in the sum shown in the appendix, subject to the cap. That is without prejudice to the employer's right to bring other claims, which would obviously include a post-termination claim for delay. We say would also include other losses if proved that are beyond the delay damages, and that's simply a facility for the employer recovering its actual loss should the delay damages be inadequate. But in addition to that, for each day of delay where the project is continuing, and quite aside from the general right to general damages, the employer is also entitled to any additional fees. So in other words, how we suggest that should be read is that the delay damages are not purporting to allow for the fees of professionals, which should be added to the delay damages where the contractor is responsible for delay. And obviously, in any event, we should be entitled to delay damages for the post-termination period. My Lord, in terms of, I don't propose to say anything further about the fees. The legal costs. I already indicated the order that was made, unless the court has questions for me. Finally, ground 5, the warranty claim. My learned friend attributed me as saying that the court could have awarded an arbitrary sum. I apologise if I did say that. That wasn't quite what I meant. The start point is, under ground 5, the contractor would have warranted its work, but in the end it hasn't carried out that work, so others have. So there's a claim in principle. The question then becomes, how is it to be assessed? And we say that there are probably 2 ways in which the court might assess such a loss. One would be to do the best one can to make an assessment of what loss over the next 10 years the employer might suffer based on other similar projects. In other words, to make a determination of how much money the employer might lose from remedying defects over a 10-year period based on other projects of a similar type, size, and having regard to the nature of the work and so on. So that would be a sort of lump sum assessment based on other similar projects. The alternative, which is the approach that Mr. Allen proposed and that the court in sort of adopted, would be to make an assessment based on a percentage of the value of the work. In other words, rather than coming up with a figure from scratch, to work out a proportionate value of the work on the basis that it is likely, if not inevitable, that the number of defects and the likelihood of defects appearing over a period of time and the cost of remedying those defects is likely to be, all other things being equal, proportionate to the value of the work. That if a very small amount of work is done, the defects are going to be relatively trivial to remedy. If a very significant project of high value is executed, it would stand to reason that the defects are likely to be correspondingly more expensive to remedy. Obviously, these are very high-level generalizations, but not unreasonable, absent any other factors. So the court has a choice between, we would suggest, between a sum of money based on general experience and whatever information is available, or a low percentage of the value of the work. And we would say that the second is obviously a better and more sophisticated approach. Instead, what the learned judge did was to calculate a percentage of the extra over, and it's not clear what basis there was for that. We say it does appear to be essentially arbitrary, having no rational basis. In short, the complaint is, if one is to apply a percentage to a base value, whatever that percentage is, 2-3% or some other percentage, the base value needs to be the right base value, and the value of the work executed is really the only candidate. It might be that the court chose specific elements of the work, or those that were most likely to fail, or those that were most likely to be expensive to repair. But taking the value of the work as a whole makes sense, or rather the work not carried out by the contractor. And we say, as a matter of principle, there's no basis for applying a percentage to the extra over. And I acknowledge my learned friend's point that the learned judge knew that he was coming up with a low value, and these points were put to him and so on. That's neither here nor there. That the court's given permission to appeal this, and now the Court of Appeal has an opportunity to give an indication as to what, in principle, is the appropriate approach. And we say it should be a percentage of the work not carried out by the contractor. Lord, if I can just check my yes, my Lord. Unless the court has any further submissions for further questions for me, those are my submissions.
Yeah. Okay. I think we have heard. Yeah. I think
My lord, I'm not going to make any
For
more
myself,
submissions.
yes.
I've had my opportunity. I just wanted to make one very minor point, is just very briefly to correct if this was the submission that my learned
Yes.
friend made, which is that I
Yes.
think it was alleged in relation to ground 1 that Mr. Allen didn't have the data in relation to the P6 files. To clarify, there is data within the PDFs, and Mr. Allen did have the P6 files from after October 2018. So that there was data from those. It's just not the P6 files themselves before October 18. If that was not what my learned friend had intended to say, then I do apologise. I just wanted to correct on that point.
Thank you very much.
Yes, my learned friend is
Thank you
correct.
very
I
much.
didn't- Thank you.
So there's no question from the judges. So
Nothing
thank
from-
you very much, Mr. Burrell, Mr. Mott. Thank you very much for your very very informative, a lot of information, a lot of things that we have to analyze, and it's going to take us some time to go through those points that you have raised with us. So give us some time for us to respond to you, or to give our decisions on this appeal, and I hope you can be a bit patient. I mean, this case has been hanging on for quite some time, so there's no real rush to arrive at the decision, I'm sure. So we'll come back. We'll let you know when we are ready to with our judgment, our decision. Okay. Thank you very much, Ian.
Thank you, my lord. I'm sure my learned friend and the parties are extremely grateful for the industry that will be required over the next few weeks and months. My lord, can I just mention, just to remind the court, that we will be putting in a hopefully very short
Yes,
submission
of course.
dealing with, and also that, as I understood it, that the contractor would be meeting the costs of that additional exercise in any event, given the circumstances in which it arose. That was the indication
Yeah,
given yesterday.
it's part of the order. I think we approved the order
Thank
this
you.
morning. I don't know whether it's been circulated.
Thank you. I haven't seen it. I'm
Order,
grateful, my lord. Thank you.
Post to the respondents, there is our order. So, Judge Lord Glennie and Judge Ali, can you hang on to this link? Can I have a few minutes before we break up for the night? You know, for the night for me, for the lunch for you, for the tea.
Sure. Sure, sir. Yes.
So,
Thank you. Thank you for sitting so late, my lord. It's much appreciated.
Indeed. And from my client, the appellant, and from myself, as my learned friend has indicated, just wanted to thank the court for indulging us the last 2 days for longer than the usual sitting hours, and for hearing all of our submissions. So
Okay.
thank you.
thank you very much
Thank you all.
for bearing with us, with all the questions too. So, Hamad, can you, Hamad,
Yes,
Hamad?
I can hear you.
Yes, keep the link on for me and Lord Glennie and Judge Ali, please.
No worries.
Can you remove all the others?
Sure.
Just leave 3 of us to this link. Thank you very much.
Thank you, my lord.
Thank you.
Thank you, Mr. Moore.
Ahmad, can you leave us too?
Yes, no worries. Shall I stop the recording?
Yes, of course, stop recording.
No worries. Thank you.
Stop recording. Okay.